Good afternoon and welcome to the Appellate Division, First Department. Good afternoon. I just put on my mic. Good afternoon and welcome to the Appellate Division, First Department. You all know the spiel. We have more than 7.5 hours of argument time requested, so I'm going to ask that you limit your time requests to the time you actually need, not the time that you want. Understanding that we have 21 cases on the calendar, most of them are being argued, and the people at the end of the calendar will appreciate it. Understand that the time is for you, not for the court. So if your argument is brilliant and my colleagues have more questions, I let the time roll, okay? All right. And before I forget, since this is our last oral argument for the season, I want to wish all of you a happy holidays, a healthy one, and a prosperous new year on behalf of this court and our Honorable Presiding Justice, Diane Renwick. That said, the call of the calendar. People versus Bilal. Submitted. Garcia versus City Meals on Wheels. Your time request? Okay. Okay.
Good afternoon, Your Honor. Brandon McTaggart, Stevenson Lee for defendant or third-party defendant, respondent, and Cynia Contracting. We're requesting 3 minutes on the coverage.
Okay, 5 and 1, 4 and 3. S. Jeremy versus Frazley P. is submitted. Medina versus 217 LLC. Okay. Okay, 5 and 1 and 4. Rodriguez versus CB Developers. Okay. All right. 1 minute? Okay. Oh, I like your time request. 3 and 1, 1 and 4. National Community versus Midtown Coalition. Okay. All right. 4 and 1 and 4. F.E. an infant versus Ibrahim. You've scared away the respondents. Would you like to submit? 2 minutes it is. Thank you. People versus Aaron Garcia. Submit. People versus Kingsley Subanteng. Submit. Magao versus Phillips and Associates. Okay. It seems you've scared away the respondent as well. So, 2 minutes, you got it. Villarreal Garza versus Ramirez. Okay. All right, 5 and 1 and 4. People versus Jawali. Submit. BH 336 Partners versus Sentinel Real.
Good afternoon, Your Honor. Antonio Perez Marquez from Davis Fulton Wardwell for defendants appellants. And we request 6 and 3, Your Honor.
Okay.
Good afternoon, the atonement of
6 and 3 and 5. Maduri versus Montefiore Medical Center.
Good afternoon, Your Honor. Scott Martin for the appellant, requesting 3 and 1, please.
Okay.
Catherine Hurst Solomon for the respondent, requesting 3.
3 and 1 and 3. Palma versus Woodside Ventures. All right. 3 and 1 and 3. People versus Traveen Hilaire. Okay. 5 and 1 and 5. Johnson versus Montefiore Medical Center. Okay. Do you have a cross appeal? Then you don't get the extra minute. So should I put it on the front end? All right. 5 and 2 and 5. People versus Akeem Massey. Submitted. People versus George Lasado. Okay. 5 and 1 and 5. Ellison Schulte versus Schulte. Sorry. 4 and 1 and 3. Wallace versus Foundation Group is submitted. First case argued on the calendar, Garcia versus City Meals on Wheels. You may proceed.
May it please the court, the appellants seek the reversal of the Supreme Court's grant of summary judgment to the plaintiff on their labor law 240 sub 1 claim and also dismissal of that claim. This is a construction site accident that occurred on a roof during an asbestos abatement. It was very windy that day, and netting was placed around the perimeter of the roof in order to prevent the asbestos from going out into the air. This netting was attached onto wooden poles, and the poles were attached via metal clamps, and the clamp in question was attached to a parapet wall via a screwing in process. And the parapet wall was about 2 feet off of the ground, and then the clamp was another 1 foot off of the ground. The plaintiff, who was 5'4", was
I know you in your papers make a lot to do about the lack of a height differential, but we have an airborne piece of wood along with a clamp that smacks into the back of this man's head, requiring extensive surgery. So clearly, the protections that were on the roof did not work as they were intended. How is that not a 240 sub 1 problem?
well, Your Honor, it wasn't the force of gravity that caused the clamp to go up because
Really?
the parapet wall was below the
The
level.
wind didn't create
Well, it did.
gravity events?
The wind caused the clamp to go across and up. It did not go down.
Does it require, where in the case law does it require that the force of gravity be going down?
Your Honor, I cited some cases.
We have had hundreds of cases where things swing to the right or swing to the left because of forces, especially wind, and have found that to be 240 sub 1.
Your Honor, specifically the Santiago versus Genting case, they were moving a crate of glass panels across a ramp, and it was a level movement. The plaintiff stuck his hand into the crate and got injured, and the First Department did find that it wasn't the
You think
force.
that's similar to this fact pattern?
I do.
No, it's not. It's not even close.
Okay.
Not even close.
Is there,
You are on a roof.
is there any dispute in terms of where the object originally came from? Is there any dispute that at some point it was attached to the upper area of the building?
Nobody actually saw the object leave the parapet wall or make contact.
So where is the parapet wall at?
It is in the northernmost section of the roof.
Okay, so the roof.
Yes.
Okay, so as it was detached from the roof at some point, is that correct?
Presumably, nobody saw it. I mean,
So you're saying that at some point prior to the accident, it was detached from the roof, and then it hung out in the air, and then the wind blew it laterally into the plaintiff.
Your Honor, I can only go by the plaintiff's
Does
testimony.
that make any sense? I'm sorry, I was being sarcastic, I guess.
I
I know.
appreciate that, Your Honor.
It makes absolutely no sense since the object was on the roof. So we know it detached from the roof and it struck the plaintiff. So I was taken by your argument because you seem to suggest that that gravity only exists in terms of items coming down, and that this lateral, if something moves laterally, then it's not by the force of gravity.
That is my argument, Your Honor.
Before your time is over, let me turn your attention to something else. You've also got an appeal pending as to the fact that Insignia's motion for summary judgment was granted as to the additional insured issue. So there's this federal case pending between Insignia and Evanston, right?
Yes.
What's the status of that case?
I would defer to Insignia's counsel because they're involved in that case. My understanding is that the carrier made a motion to dismiss. That motion was denied. The carrier made a motion for reconsideration, and that motion is pending, but I would defer to Insignia's Insignia's attorney as to that issue.
Okay, you'll have time on rebuttal.
Thank you, Your Honor.
Thank you.
Good afternoon, Your Honors. Kenneth Gorman for the plaintiff respondent. The power clamp was a safety device, and it was used to protect workers from the gravity-related dangers on a construction site. Dusan Zorak, Insignia Contracting's owner, testified that the metal clamps were used to secure the post to the parapet wall.
Counsel, the sheeting that was attached to the paraclamp, that was situated 9 feet above, atop the roof, is that
I believe it was 10 feet.
10 feet?
Yes, if I'm not
Okay.
mistaken.
And is it your argument that it was the load that required securing as opposed to the individual paraclamp?
It was the paraclamp secured the post that in turn secured the tarp that protected the workers. At the very least, it's our position that under Ladd versus Thor, the paraclamp was an essential component.
When it came down, did the whole thing come down?
No, just the paraclamp. And
What about the sheeting?
the sheeting? I'm not aware of the sheeting coming down.
Isn't there a photograph with the sheeting on the ground?
Not that I'm
When
aware
they go to the plaintiff?
I
It's all
think-
white stuff. I assume that it was the sheeting.
I'm assuming it, but I can't say for sure. I mean, I don't want to make an assumption that's,
It wasn't the sheeting
Attached.
blown by the wind?
yes. What I understand, the post and the paraclamp flew off. Some of the sheeting probably fell as well.
I mean, someone
The
testified.
sheeting was attached to it, yes.
Someone testified that they didn't want to use that
Paraclamp was defective.
pad piece earlier in the day because it was defective, right?
That's correct. I mean, the clamp was defective, and that's the reason why they couldn't secure it properly to the post.
And when we're saying defective, it was because it was bent.
That's correct. It was bent. And it was foreseeable that a gust of wind on the roof would cause this to become detached and hit the work.
Have you had occasion to look at a case called Brito, B-R-I-T-O?
Yes.
How is that case similar to, or dissimilar from the facts that we have here?
I'm not really familiar with the facts. I did review it, but in that case, I believe
That
a
was an
gust of wind.
asbestos removal case
Say it again?
where the fence panels hit the plaintiff. Those panels were not secured by heavy sandbags or metal plates.
That's
They
correct.
weren't tied down. So is that similar?
I-
Is that on all fours, or is that different?
Well, it's similar. I mean, it's similar insofar as the safety device was not properly used. The safety device here was not properly secured, and as a result of the gust of wind, the safety device flew off.
Did any of the experts posit what the correct or typical safety devices might be in this set of circumstances?
I don't believe the defendant's expert had any other alternative. He said that the paraclamp was not a safety device, but under Zimmer versus Chung, an expert cannot give an opinion with regard to an adequate safety device on the label of 241. The standards under the label are different than what an expert would normally encounter on a construction site.
Has an expert stated anywhere that it was the screws that were an issue, that the paraclamps and the posts weren't screwed properly, or has that not been discussed yet or
I'm not
testified
sure.
to?
I don't recall him talking about the screws. He might have, but I mean, there was no evidence that the screws were effective at the site.
Well, they certainly were insufficient to secure the clamp.
That's correct.
Okay,
Thank you.
may proceed.
Good afternoon, Your Honors. Brandon McTagg of Stevens and Lee for Insignia. We respectfully request that the court uphold the portion of Justice Hagler's May 21st decision in order for summary judgment and the portion granting.
Is the federal action between Insignia and Evanston, is that case still alive?
Yes, it is. Mr. Kennedy gave a good recitation of where it's at.
So if Evanston should win that case, why would you be entitled to summary judgment here?
We're entitled to summary judgment because pursuant to the contract, we got the appropriate coverage for the issue. If Evanston were to win in the federal action, which I don't believe is going to happen, they advanced the same bodily injury defense that is at issue in this action, and Justice Garnett rejected it. So there doesn't appear to be any.
What establishes that you got the appropriate coverage, appropriate additional insured coverage, as opposed to, because Supreme Court seems to have decided that insurance issue based upon the fact that Insignia would be covered for its indemnification obligations to City Wheels and Hollister, but City Wheels and Hollister are seeking additional insured coverage. They want additional insured, I guess, primary coverage from Evanston. If Evanston prevails in federal court, how will you have satisfied that contractual obligation?
Well, I would say that Justice Hagler did not make that determination. I explicitly went to argue the additional insured issue before Justice Hagler. He cut me off and said that he didn't think it was an issue anymore, and Mr. Kennedy waived that argument.
Why isn't it an issue?
Because there are two forms that explicitly state that City Meals and Hollister are additional insureds under the policy. I believe it is endorsed.
But isn't that issue the issue before the federal court, that very issue as to whether coverage applies?
Yes, that issue is before the federal court among the other issues.
So it hasn't been resolved.
It has not been resolved, but as a matter of contract, they are additional insureds.
Thank you.
Thank you.
You have 1 minute on rebuttal.
Just very briefly on the breach of contract issue. The contract said that the policy must have no exclusions from liability other than part of a standard, basic, unamended, and unendorsed form of policy. What's at issue here is basically an additional amendment that doesn't give us the coverage that we bargained for, so we submit that there is a breach.
And there were specific endorsements that were required under the subcontract, and those are not in the record as far as I could tell.
That is absolutely correct, Your Honor.
We really, based upon this record, have no means of making a determination whether what was provided was in fact was required.
I agree, Your Honor. Thank you.
Thank you. Medina versus 217 LLC. You may proceed.
Justin Wadewitz, Siegel McCambridge for defendant appellant 217 LLC. May it please the court. Defendant appellant appeals the denial of their summary judgment motion on liability based upon the following facts. The plaintiff, Brenda Medina, was employed as a home health aide and was doing her work for a resident on the 5th floor when she allegedly slipped and fell on accumulated water 4 steps from the front of the door on the landing. The initial issue on appeal presented is that the plaintiff's expert, Vincent Peachy, should have his report precluded on several bases.
So you represent 217 LLC, right? Is that
Correct.
correct? So how did PK relinquish the control? How did you relinquish control of the building to PK management?
PK was employed as the premises manager. They were in charge based on the testimony of the building super, as well as PK's own affidavit of Kreyat-Sulis. They were tasked with all aspects in terms of the maintenance and supervision of the building on the day-to-day aspects. They did daily walkthroughs. They patrolled the building.
Is there an agreement?
There is no written agreement that I'm aware of. It is a verbal agreement.
So again, so how did you relinquish it? You're stating that you relinquished control based upon the actions of PK, but not based upon any type of written agreement wherein they agreed that they were going to take over the control and maintenance of the building?
Yes, Your Honor. And in terms of a defective condition, it is found that the water accumulation is not.
Well, both the plaintiff the plaintiff stated that she had reported it. She also stated that the individual with whom she worked had reported it, and that individual's nephew had also reported the accumulation.
Yes, Your Honor. There are hearsay issues with the statements of the woman she worked for as well as the nephew.
Well, the nephew's dead, so we can't do anything about that.
Understood. And essentially, the plaintiff's own statements to the handyman do not take into effect the plaintiff's own statements as to where the hazard was located in terms of the light fixture on the ceiling in front of the building's door on the 5th floor landing versus the testimony establishes that there was potentially notice of a bubbling condition in the paint from the.
So your motion, it's your motion for summary judgment. She states that she reported it. What did you come back with to say that it was not reported, that you did not have notice?
I'm coming back with the fact that the two conditions based on the location and the plaintiff's own testimony are separate. There's a separate location between the skylight on the 6th floor and the wall going down to the 5th floor landing.
Mutually exclusive.
Well, based upon that and the expert.
Two are not mutually exclusive. The fact that there may be bubbled paint doesn't mean that there isn't water collecting by the step. So, back to my colleague's question, what evidence did you produce to show that this manager was not told about this problem, other than his saying so?
We have an affidavit from the property manager himself and the testimony of the handyman.
Let's talk about the experts a second.
Yes.
We have conflicting testimony, don't we? Mr. Peachy talks about a defective bulkhead and a skylight due to lack of maintenance, and the photographs, there's photographs that corroborate not only that, but also blistering paint on the interior. And Mr. Marpet, the defendant's expert, says there's no evidence of water stains or anything that would indicate water damage. So that's pretty diametrically opposite.
We're arguing that Vincent Peachy's expert report should be excluded. There's no probative value to the condition alleged on the date of loss. It was done 4 years later, and most importantly,
Wait. Yeah.
correct.
They were both done in 2021. Actually, Mr. Peachy was June 10th, 2021, and your people's
Sure.
guy was October 6th, 2021.
I understand that, but the difference is that our expert performed actual scientific testing on the landing of the floor.
Let me take you back.
using
Mr.
a
Peachy's
thermometer.
photographs were
Let
no.
me take you back to the out-of-possession issue for a moment. So you're saying that the owner puts in a managing agent that makes the owner an out-of-possession owner?
I'm saying in this case, with no written agreement regarding the positions that, based on what we have, the affidavit and the testimony, that correct, the control.
that's that.
You want us to
control is
create
not
new
there.
law that if a landlord does not enter into a written agreement, then that landlord gets a pass on any liability that happens in his building by just having a manager. That's the law you want us to
I
create?
do not, Judge. Thank you.
Well, how else would you be out of possession? That's what I did not understand. I was asking initially what evidence there was that you had relinquished to PK, or, yeah,
Right.
PK.
And the
You
argument,
have nothing, so therefore, I don't understand how you become an out-of-possession landlord.
just because there's no written agreement based on the
So again, no written agreement equals a pass
course of conduct
in the
between
state of New
parties.
York for landlords. That's the
Not
ruling
my
you
best
want us
argument,
to do.
Judge, yes.
That's your best argument?
That's not my best.
Thank you. You'll have time on rebuttal.
Afternoon, Your Honors. Joshua Block on behalf of the respondent. I just want to begin by pointing
Why
out.
don't you have, in terms of trying to establish actual or constructive notice, rely on the fact that plaintiff passes along statements made by her employer? Why isn't there a hearsay issue about that?
So that's not the only statement. The plaintiff says she herself also complained to the super about the issue. That's on pages 187 to 188 of the record. So Your Honors don't even need to reach the issue of the employer or the employer's nephew, because the plaintiff herself says, I talked to the superintendent, and
Which
I
then means that the evidence of her employer and the nephew, while arguably hearsay, is not the only evidence in the case and therefore permissible to be considered by this court.
Yes, Your Honor, absolutely. I would also add the nephew died, and therefore that is admissible. And
So you're saying that the plaintiff herself told,
yes, Your Honor.
who did she tell?
The superintendent, Mr. Zapata.
And she said she spoke to the superintendent the day before she fell, right?
Yes, it's page 187 to 188 of the record, Your
Right.
Honor. If I may go back to what I was about to say, though, I was going to point out a mistake in my own brief. I misstated a fact in it that I just want to clarify.
Okay.
I had said that the owner of the management company and the owner of the premises were one and the same. That's a mistake by me. They're not. One of them is Kostas Kriatsolas. The other one is Peter Kriatsolas. And this gets back to the very last point raised by the defendant. Peter Kriatsolas, who's the owner, who's the prior owner, who's listed on the deed, is the same person who paid the invoice. The deed is page 55 of the record. The invoice is page 58. So, setting aside the fact that there is no evidence of what this oral contract is, you also have course of conduct that the owner has not given up possession and control, because the owner, the person, this Peter, is the one who paid the invoice to fix, or not to fix, to replace the window on top.
Skylight.
The skylight. Thank you, Your Honor. I'm sorry, I'm a little bit nervous, but yes, the skylight. Relatedly, it's not a changed condition when Mr. Peachy comes, because what he's saying is this was improperly installed. So the installation is not something that changed. Similarly, I believe it's page 389 to 390, that portion of Mr. Peachy's affidavit shows why the water collected in this spot. He uses the balls, I believe that there was ping pong balls, there's a picture of it, to show that this was a dip where this water collected. And the water is not being obviously produced by a light, it's coming in through the doorway or through the skylight. It's coming in because the top isn't properly weatherproofed, and then it's coming through as water does, runs down the walls, it drips down.
Right, but
this is
the
where it collects.
defendant's expert states that there would have been some bubbling, and there was no bubbling.
I believe our expert does say that there was. And we've got testimony from the plaintiff as to the rusted condition that she sees on the walls and bubbling. And at worst, when our expert says, when our plaintiff says, and their expert says something different, that's a triable issue of fact.
I'm curious about the photographs.
Yes.
Because the photographs appear to show water damage and I'll say the possibility of water penetration. When were the photographs taken? Who took them? Because I didn't see that.
I'm not sure off the top of my head, Your Honor.
Do you know? So both of the experts were there in 2021, several years after the actual accident occurred in 2016. Do you know if the photographs were contemporary or not?
I'm sorry, I don't know off the top of my head.
I couldn't.
And I don't
couldn't
want
find
to
it.
make a guess and be wrong, Your Honors. If there's no further questions, I'll rest on my brief. Thank you.
Counsel, you have 1 minute.
Thank you. Briefly, to answer Your Honor's question, the photos were taken by the tenant's nephew shortly after the accident, which again brings into the hearsay issue with the nephew's testimony.
Yeah, but he said that the plaintiff herself told the super
That is her.
about the water condition.
That is the testimony, Your Honor. But if
The
you,
photographs by the nephew do not create a hearsay issue.
we
The
can't.
photos speak for themselves. All they need to be authenticated is that someone recognized them for what they are. So there is no hearsay issue with those photographs.
There's no hearsay issue in the case at all if the plaintiff herself complained.
Well, but the issue
I
of
mean,
the,
then it's just clearly an issue of fact created, and
the issue, Judge, is the actual substance of the complaint and the location of where she fell versus specifically separating it from the area dripping from the light fixture, which was 4 steps from the door, versus the skylight and the steps leading from essentially the
Because
6th
water
floor to the
doesn't
5th
travel.
floor.
Thank you.
Thank you.
Rodriguez versus CB Developers.
Good afternoon. Howard Fishman from Smith Major, representing the defendant appellants, CB Developers in 1314. It's our position that Justice Rosado's June 17, 2024 decision and order, which granted plaintiff's motion for summary judgment as against 1314 and CB Developers was incorrect because there's been no discovery in this case, been no depositions in this case. Justice Rosado found.
Did you highlight what evidence was missing and necessary that discovery is required before this court or the court below issue a decision?
Yes, we did.
And what is that?
Well,
'Cause I don't see anything missing from what was before the court on this particular issue. So tell me, what is it that discovery might yield that would save this case from a 240 sub 1 finding?
Okay, well, Your Honor, we don't know who employed the plaintiff. According to the bill in particular, it was Albert Demolition, which is a non-existent entity. We retained an Albert Environmental. Their invoices say Albert Services, ARC.
Who he's employed by doesn't really, unless you are the employer and are asserting a worker's compensation defense, is irrelevant to the issue of 240 sub 1 liability. So again, I ask you, what is it that is missing in terms of information that your client would not be privy to on their own from being on the site that is required for the court to consider this 240 sub 1 motion?
Well, because we don't know the employer, we don't know who his supervisor was, we don't know what his instructions were given, what instructions are given to him by his supervisor or by his employer. We don't know what safety devices were provided.
And you are whom to the plaintiff?
We are the owner of the building.
So you have a non-delegable duty under 240 sub 1. So tell me what, again, I keep on asking you, and you're giving me a lot of statements that say nothing about why you cannot defend yourself on a 240 sub 1 as the owner who must provide a safe workplace for a construction worker.
Because, Your Honor, this is an asbestos-related issue.
It's still construction.
We leased the premises to Foot Locker. They were in possession of the premises.
That doesn't get you out under 240 sub 1. You are an owner. So tell me, what is missing that you as an owner could use as a defense to a 240 sub 1 strict liability claim?
We don't know what the plaintiff was doing. We don't know what.
Stipulated, your 1314 development?
We're 1314.
1314 development stipulated that plaintiff was a worker engaged in asbestos removal on the premises. Is that correct?
That's correct.
Okay. Plaintiff, in his affidavit, stated that he was attempting to descend from the roof when he was working in asbestos-related removal. He had to traverse the metal beams, and he slipped and fell through the sheetrock into like 2 floors below. That's on. So what other, and there was no protective devices provided to him. Again, as my colleague stated, you're the owner. So what additional discovery would be necessary, what additional discovery would be, would be necessary in order to refute any of that?
Because we need the deposition of first the plaintiff as to what he was doing specifically at the time.
And that's what he testified to, right?
But we should have an opportunity to explore that.
Explore what? He said what he was doing. He said he was descending. He was attempting to descend from the roof. He had to traverse traverse narrow metal beams covered by plywood that had been removed. He slipped and he fell.
Because the affidavit that was submitted by Albo Environmental creates questions of there being plywood at the location where the accident occurred.
But it was, according to him, he stated it had been removed.
Well, there's a picture that's attached to Mr. Chimcherowski's affidavit, which has a photograph of plywood.
So you're stating that the additional discovery that you would need would be to depose environmental?
Well, we need to depose at least plaintiffs to find out who was working with him. He identifies a number of, he says that there were unidentified individuals working with him that supposedly removed the plywood. We don't know
Counsel,
who
I'm
these
looking at
people
the
are.
photographs. There's one at A300, Exhibit 24, that shows plywood how do you say, crossing some of the tubing as well as beams, and there's definitely not uniform plywood throughout. There's just one board atop the other. Then you have another picture at 317, which is also Exhibit 35 to the Wilson Affirmation, and it shows the ceiling, the ceiling of the bathroom and holes in between the beams where the plywood is hanging down. And there's also photographs of this man falling, how do you say it? The sink where he hit and actually broke the sink when he hit. So I don't understand when you say that you don't know what happened.
Well, we know he fell, but what was he doing at the time he claims that there was
No, the
asbestos?
issue is what protection was he provided when he was doing his work that would prevent his fall?
That would have been-
That is the issue, and you'll have time on rebuttal, sir. Next. I believe you asked me for 1 minute.
That's correct, Your Honor. Good
Your
afternoon.
Foot Locker?
Foot Locker, that's correct.
So, counsel, is it correct that there were no safety devices, there was no safety netting, no rail, no belt, no harness, no lanyard, and no lifeline?
Well, again, no one's been deposed. The only reason I requested 1 minute was that the only party that had appealed from any part of the order that was in favor actually of my client, was the owner, and the owner on reply has withdrawn that part of the appeal. No one else has appealed from that determination, so there's no issue before this court with respect to my client's liability.
Right, that's why I asked you were Foot Locker, because you didn't appeal, right? I mean, you're not aggrieved, there's nothing.
We're not aggrieved by the decision, the
Exactly.
cross motion. Right, and we can refile depending on what discovery shows.
Exactly, but you're not aggrieved.
We're not aggrieved, no.
Thank you.
Thank you.
Thank you. You have 1 minute.
Your Honor, the safety devices would have been provided by either Alba Environmental, Alba Services, or ARC. Those were the entities that were on site. We were not on site at the time.
We understand that.
we delegated-
But you understand that under the labor law, an owner of a building has a non-delegable duty. So the failings of your GC, fall upon you as well, unfortunately.
Unfortunately, they do, but that's the basis for indemnification claims. But in terms of the facts, those facts are in the exclusive knowledge of either the plaintiff, his supervisor, the contractors that
Or
were
the
performing the
defendants
work.
that you hired to oversee the project.
Well, we didn't oversee the project. We were an absentee landlord.
It said your GC who you hired to oversee the project.
Correct, but we should be entitled to conduct their depositions to find out what devices they provided, what devices were on the site. I don't know whether the plaintiff's affidavit is truthful or not. We haven't had the opportunity to explore that. We should have had that opportunity to explore those issues before summary judgment was granted against us.
Thank you. Have a good evening, gentlemen.
Thank you.
National Community versus Midtown Coalition. You may proceed.
Good afternoon, Your Honors. My name is David Wolf, and I represent the Plaintiff Appellant National Community. Special hello again to Justices Weber and Gonzalez. I believe you were on the bench the first time the issues presented on this appeal were conclusively decided by the court. As the full panel is aware, this is a simple action to collect unpaid rent owed by a commercial subtenant. This court already decided as a matter of law that $269,234.41 were owed as of April 16th, 2021. From May through November, when
Doesn't the defendant say that, look, you can't come after us because we had various things going on, and at the end, you bring a holdover proceeding, we enter into a stipulation, the stipulation constituted a new agreement, you needed to have the main landlord, the primary landlord's consent to this, you didn't get the consent, and therefore we're no longer bound by anything.
Yes, Your Honor,
What is your answer to that?
well, number one, the answer is that precise argument was heard and rejected, and for good reason, by this court in the appeal by the guarantor. They made the exact same argument. Since they're in privity, we don't do a do-over. The collateral estoppel applies. And I mentioned there's good reason that this court reached that decision the first time this issue was presented. The reason the court did that is because the
stipulation of settlement?
The stipulation of settlement was clear that it
didn't constitute a new lease.
Didn't constitute a new lease.
Paragraph 7. Sorry. It said, paragraph 7, except as herein explicitly modified, the sublease shall remain unmodified and continue in full force and effect.
That's correct. And additionally, there's case law that we cite where the lack of landlord approval can't invalidate a settlement or can't invalidate a lease because they reaped the benefits of the agreement. They stayed in possession after the stipulation of settlement was signed. The holdover proceeding was discontinued. They paid rent at a reduced rate. This is an afterthought that they came up with years after signing this settlement agreement. And so there's one of the truly baffling things about this argument is that the subtenant argues that if the stipulation of settlement were invalidated, well, then we'd be able to walk away scot-free without paying any rent at all, which is completely nonsensical. What the stipulation of settlement did was it reduced the amount of arrears that were owed as of the date the stipulation was signed. It reduced rent going forward. So guess what? If that were invalidated, their liability is substantially higher than the $411,000 that they owe. So that's not a defense at all, even if it were legally accurate, which it isn't, factually accurate, which it isn't, or subject to relitigation, which it isn't.
And we also stated that the stipulation of settlement was a modification and that it unambiguously continued the sublease in full effect.
It did. It continued.
Except as modified by the stipulation. That's what we said in the first case.
Right. So the sublease remained in full force and effect. They remained in possession. They just don't want to pay rent for the time that they refuse to give the space up. There's absolutely no reason that they should be given free use and occupancy of the space or not have to pay what they agreed to pay. None of their defenses have any merit, and quickly, besides that one about the stipulation, they didn't raise or follow through with any in their opposition or cross-appealing briefs, and all other defenses should be deemed abandoned. Thank you.
Counsel?
Good afternoon, everybody. I'm James DeCristofaro for the cross appellant, and I didn't realize, forgive my ignorance, that I could also request time. So can I, on rebuttal, so can I change my 4 to 3 and 1? Would that be possible? Thank you. First of all, this issue has not been decided by the panel. These are two different...
Whether it's been decided or not, the fact remains is that the stipulation says that except as herein explicitly modified, the sublease annexed hereto as Exhibit A shall remain unmodified and shall continue in full force and effect. So where does this need for consent come from, since it's not a new sublease, and you agree to that.
Thank you. There's a couple of ways that we pick apart that question. Number one, there's the master lease or the primary lease.
So what you got to pick apart is the agreement,
Well, so,
right? Because how do you get past that language is what I want to know.
well, we have to pay attention also to the except as provided in section 5.A. 5.A changes the rent. Don't you think that the landlord would be interested in a change in rent provision? That's a
So
material
that's a
provision.
rhetorical question.
Well, that's
Because
why.
you don't get to ask this court questions.
Well, okay.
Make your
That was a
argument.
rhetorical question, right, Your Honor. My apologies. So the one thing that's missing, and it's a very material thing, there's two things that are missing from the record that Mr. Wolf cited before, which when the court looked at this for the first time, and now. What the court has now and didn't have before were two letters. Those two letters are March and April of 2019, I believe, and they're found at the record pages 118 and 120. And it says in no uncertain terms, they're letters on behalf of the landlord that says, now that the sublease has terminated or your sublease has terminated.
Counsel, I'm going to direct your attention to our decision in October 2022, where we said that the stipulation was a modification that did not relieve the guarantor in that instance of its obligations. And we also said that language established that plaintiff, the primary tenant, and the subtenant did not intend to extinguish the sublease and replace it with the stipulation as a novation, right? So did you go to the Court of Appeals and turn around what we decided in 2022, or am I missing something?
We didn't. The thing that was
Therefore-
missing from that.
Therefore, how can you argue that now?
Because
That there was something missing then?
Because these are, okay, first of all, collateral estoppel doesn't apply because the way,
Counsel,
yes.
you know the law just like we do.
Mm-hmm.
So you had to appeal that prior decision. You don't get to back channel appeal it here. That's not going to happen.
Okay, there was a different record with different parties, and this, in my view,
The
wasn't
ruling
back
is
channeling.
the ruling, and we are stuck, bad or good, with that ruling. So that's your starting place. You don't get to re-argue that.
Okay, thank you.
You have 1 minute.
I'll yield my minute.
Okay.
The ruling is the ruling.
Thank you.
I don't have
a
anything to add to
great
that.
holiday
Perfectly said,
then.
Your Honor. Unless the court has any further questions.
Thank you. F.E. Infant versus Ibrahim. I understand your adversary arrived late. Counsel, the calendar call here is at 2 o'clock. Okay? So are you the appellant? The respondent. You can have a seat. You'll get the same 2 minutes. Go ahead, counsel.
Good afternoon, Your Honors. May it please the court. My name is Timothy Gallagher of Schaub, Albany, Citron, and Spratt for the defendants' appellants, Dr. Santiago, Dr. Kulkarni, Dr. Verna, and Bronx Lebanon Hospital. Respectfully, Your Honors, the order denying defendants' motion to dismiss the action for neglect to prosecute should be reversed. This case was filed in 2012. It's been going on for 13 years.
A lot of that would have to do with all the delays, right? There's huge gaps in the chronology of this case where nothing happened, things that had to be done by the plaintiff.
That's
Am I
correct, Your
right?
Honor. That's correct. It was.
Oh, you're defended? Oh.
But not just the plaintiff.
Oh, and the defendant.
sorry.
Yeah, the defendant as
The
well.
defendant lost the sonogram. Am I right?
Well,
No, they didn't lose the sonogram. They destroyed the sonogram.
well, respectfully, Your Honor, that issue's not what's before this court. That was already decided in plaintiff's favor, the spoliation issue. But the other discovery, the defendants weren't the ones causing the delay. In fact,
Counsel, there's never one-sided delay on a case, ever.
well, Your Honor.
There's delay on both sides, as there was in this case.
Well, respectfully, Your Honor, defendants were reaching out to plaintiff's counsel, trying to schedule defendants' depositions, but ultimately only one deposition was taken. It was more than 4.5 years before plaintiff even filed the notice of medical malpractice.
Counsel, this is
Spoliation
a,
shed any light on the issue of a meritorious defense in terms of the issues in front of us now?
Sorry, could you repeat your question?
Does the spoliation of that sonogram shed any light on meritorious defense in terms of the issue that's in front of us now?
Respectfully, no, Your Honor. The spoliation issue is completely irrelevant to the neglect to prosecute issue. They're two separate issues, and that was the one part of the that was the focus of plaintiff's motion. But plaintiff also didn't meet the burden of explaining why the case should not be dismissed, because plaintiff didn't file the note of issue.
You know, we have a plaintiff, this case has been going on for quite some time. People move, as this plaintiff did, and lost contact with her lawyer for 3 months. That doesn't seem like an inordinate amount of time to this court, or at least not to me.
Well, perhaps not towards the later period of the litigation of this case, but that still doesn't explain why, it took.
Again, I know you'd like to blame the plaintiff for all of the delays in this case, but we all know better that it doesn't happen that way.
Well, respectfully, Your Honor,
Right?
the defendants were.
And I'm sure that the plaintiff was, I don't know, how many times did they ask for the sonogram strip and didn't get it? And then the hospital, as a part of their normal purging of records, destroyed it? So there's enough stuff going on in this case on both sides. So the question is, what evidence is there in this record that the plaintiff here intended to abandon her child's case?
Well, Your Honor, all plaintiff had to do after being served with the 90-day notice was.
Except that she moved, so she likely didn't get the first one.
Well, respectfully, Your Honor, it wasn't sent to her, it was sent to her attorney.
Right, and he couldn't get it to her because she had moved and she had failed to tell him where she was immediately. So why is that not a legitimate excuse for a 3-month delay in this last instance, which is what we're talking about?
It might have been, Your Honor, but the issue here is that the plaintiff didn't make that motion to present that legitimate excuse within the 90-day window. Plaintiff waited till afterwards, and then even then, didn't even.
Afterwards, by how much, counsel?
A day?
By 3 days.
48 hours at most?
3 days?
3 days max.
3 days, but.
So we should send a child who was injured at birth through alleged malpractice of this hospital, whose evidence to support it was destroyed by the hospital. We should not allow that plaintiff to continue with their case. That plaintiff, that infant plaintiff,
Well, Your Honor.
who was injured at birth and whose evidence to show that they were injured at birth was destroyed by the very hospital they're suing.
Your Honor, the law makes no distinction between different plaintiffs. They all have the obligation to prosecute their case.
Okay. You'll have time I'm gonna give you a minute on rebuttal since he got here. Okay? Counsel?
Good afternoon, Your Honors. I believe that the.
Appearance, counsel, please.
Oh, I apologize. Gary Rollins for the plaintiff, Mina Zorkani.
So your adversary focuses greatly on the untimeliness of the application to the court. Why was it late?
In that particular part, the court requires us to get approval before we file a note of issue, at least at the time. In addition to that, when I filed my motion, which I believed was timely, and I still believe it was timely because they mailed it and they had the wrong address on there for my office, they will contend that they sent it via e-filing. I got the notice, and that's what I put up on my over my desk. In any event, when I made my motion, I explained to them, we were having conversations. They knew this was going to happen. I told them, listen,
So there was no time during this motion practice that there was dead silence from your office?
No.
There was no reason why they should think that you and your client abandoned this case?
No, they 100% knew that that motion was coming. They were asking for depositions that were
I
not.
mean, there's no question that your motion is late, whether it's a day or 2 days or 3 days. What you're saying is that you told them before you made that motion that it's coming? Is that what you're saying?
To be clear, we were having, Your Honor, we were having settlement conversations. The conversations went cold. That notice came by mail somewhat late because they mailed it to the wrong office. And then I made the motion to strike.
Extend your time. You made the motion to extend your time, but it was slightly late.
More than extend the time, I wanted to strike their answer for destroying the sonogram.
Counsel, you said that you needed permission to file your note of issue. What was the perceived impediment to you getting that permission? Was there still outstanding discovery that kept you from being able to file that note of issue or
Right, so-
seek permission to file it?
Right, so when we learned that the sonogram was destroyed, I didn't need to take additional depositions. I needed permission to file my note of issue. And so rather than file a note of issue without that issue being resolved, that they would either have some sort of sanction or their answer would be stricken, I made the motion, requested the relief from the court, and it's my understanding that having done so, that would have relieved me of the obligation to actually file a note of issue because it showed action in the case.
Got it. Thank you.
Thank you, Your Honors.
Counsel, you have a minute.
Your Honors, respectfully, plaintiff conceded that there was the issue about the service via NICEF.
Counsel, this statute is an extremely forgiving statute, right? That's the way it's been defined in case law, correct?
That's correct, Your Honor.
So why shouldn't we affirm the trial court's determination, given that aspect?
Well, Your Honor, respectfully, it's forgiving in the sense that there's a lot of ways to avoid dismissal. And frankly, here, plaintiff...
No. It's forgiving when arguably dismissal would be appropriate. That is what the case law refers to when it says it's forgiving.
Well, Your Honor, my understanding is that it's forgiving in the sense that there's a lot of ways to avoid getting to this point, and that would just
Well,
simply...
then almost every statute has a forgiving nature of it. So I don't think that's what our case law meant.
Well, plaintiff, because the response was late, plaintiff needed to when she made the motion, she needed to demonstrate an excuse for the delay, which she never did in her moving papers, and a meritorious cause of action, which she didn't do. So she simply didn't do what she needed to do to avoid dismissal.
Thank you.
Thank you.
Thank you,
People
Your Honor.
versus Aaron Garcia.
Submitted.
Submitted. Oh, sorry. I'm looking at the wrong sheet. Okay. Macau versus Phillips and Associates. And you requested 2 minutes.
2 minutes, because it's just me, Your Honor. Michael
Yes.
Confuciano for the appellant. In my brief 2 minutes, I'd like to focus really just on the intentional infliction of emotional distress and the tortious interference with business relationships. This is, I guess I would say this, if you look at the allegations of the complaint, and it was on a motion to dismiss, we have to construe them in the light most favorable to the plaintiff. This isn't just about filing a complaint, as the judge's decision was promised on. If you look at what the plaintiff alleged, she said, one, the defendant law firm had the information in its possession that it knew, including that their client said, leave your husband or I'll sue you. So they already had the information knowing that he was trying to extort her. But the most important thing is, it's the way they used the information. Not only did they file the complaint, but they took a draft of the complaint and they circulated it to the students of the plaintiff's dance academy.
Is that an allegation, or is that corroborated by any type of affidavit by a non-party who actually received a copy of the draft complaint?
It's an allegation, but at this stage of the case, Your Honor, it's sufficient because it's a motion to dismiss standard.
And
Doesn't
what is the proper counter? Is the proper counter a statement or an affidavit from the the defendant saying, our firm never distributed the complaint to non-parties? Or did the firm have to go to the students of this dance academy and ask them, did you get a copy of this salacious complaint?
I don't think they have to go to the students and ask them, but
But then what is the counter? What is the negative? How do you prove negative proof?
well, if you're on summary judgment, that would be one thing. They could move and say the plaintiff has a lack of proof to show that anybody even received the complaint alleged, and if that's a ground to
No, I'm asking, how does the defendant meet his shifting burden of proof?
well, I think that is how they could meet it.
It's
In other words, if you're the defendant and it's a summary judgment, you can point to the absence of evidence. But here, we're only on a facial look at the complaint.
So I thought that the dissemination or the alleged dissemination of the complaint to the students went to your defamation claim and not to your tortious interference claim.
I think it goes to both, Your Honor, because
Is that what you alleged in your complaint? Because I thought the complaint only alleged it as to the defamation and not to the tortious interference.
well, I think it alleges to both because it's in the factual narrative and that leads up to the claims, which of course they all say we incorporate the references before. But if you look too at page 3 of the judge's decision below, the judge dismissed intentional infliction of emotional distress by saying it doesn't rise to the level of outrageous or extreme conduct. And I think that, along with there's another allegation in paragraph 44 where the plaintiff alleges that they assisted this client in filing a false rape accusation.
Well, yeah, I thought the tortious interference was predicated on the commencement of the Hodges action.
Tortious interference?
Yes.
I think it's principally probably premised on the fact that they circulated the
And
complaint.
that the defamation claim, again, was based upon the allegations that it was disseminated to the students.
I think you could construe the complaint that way, but I think on a motion to dismiss, it ultimately doesn't matter. If one of those is sufficient to sustain a claim, then the whole complaint shouldn't have been dismissed anyway. And again, I think...
Okay, well then on the
Yeah.
defamation claim,
Mhm.
what are your allegations other than the dissemination to the students?
I think
What else do you have? What are the allegations you have on the defamation claim?
I think it's principally that, but along with the filing of the rape complaint.
Along with the,
Filing of the rape complaint, that's paragraph 44.
on the defamation?
Yeah, I think that goes to it. Again, I think the factual narrative in the beginning of the complaint is incorporated into the causes of action. I don't think at a standard of a motion to dismiss, you have to be that definitive on it. And even if we did, then why didn't the court permit her a chance to amend the complaint? And getting back briefly, I know I'm way over 2 minutes.
Yes, you are.
Just to answer Your Honor's question, I think the critical part is, if I was on a summary judgment, I'd be in a much worse position. But the fact that it's a facial dismissal of a complaint, and you have to construe them in the favor of the plaintiff, this is enough, I think, on those principal allegations to withstand the dismissal motion. And on that, I would rest my argument. Thank you for giving me time, Your Honor. Appreciate
You
it.
are welcome. You
You too.
BH 336 Partners versus Sentinel Real Estate.
You forgot.
Yeah.
Villarreal.
Skip one?
Yeah, Villarreal.
Yeah.
Oh, I'm sorry. Give me 1 second. You might as well get in the wing because you're next. All right. Villarreal Garza versus Ramirez. My apologies. Thank you.
Good afternoon, Your Honors.
Good afternoon.
I'm going to have to also apologize for miscalculating slightly the amount of time that I need. So
Don't worry. Like I said, if you're brilliant, we keep asking questions.
I don't know if
Go
I'm
ahead.
brilliant, Your Honor, but I have a matrimonial case to put before the court, so I hope you'll indulge me. So, Your Honors, this is an interlocutory appeal by the wife in a contested matrimonial. And so far as I'm concerned, this is a case of first impression, namely,
What impression is it? Really, how is it a case of first impression?
Yeah.
Based upon what?
Yeah, well, in a deposition where a husband is admitted to committing marital waste over a 15-year period by spending funds on paramours, the question which the motion court denied, or opined in the negative was whether or not the husband could be examined as to the identity of the paramour so that probing questions could be asked regarding marital waste.
I don't think that's an issue of first impression. I think that's an issue that has been decided time and time again.
Well, in that case, Your Honor, maybe I should have moved in a different format because the motion court was extremely adamant about the fact. Then my job is very simple, Your Honor. The motion court was adamant in not allowing me to do so, even though I cited.
No, the issue is how the money was spent.
Right.
How the money was spent. You wanted to get into issues in terms of who the paramour was, whether or not the husband had other girlfriends, those types of questions, which were not relevant. It was how the money was spent.
No,
and to some extent, who the money is spent on, yes.
I disagree, Your Honor.
But the
respectfully.
exact name of the
the name.
paramour is not relevant to financial waste. What's relevant is that it was spent on a paramour and how much.
Right, except for one thing, which is that when I have airline tickets made out in the names of multiple people, and I'm not able to ascertain the nature of the relationship of the husband who admitted spending the marital waste, I don't know if this is a casual acquaintance, a business companion, or a paramour. And
Well, why not ask that
it's
question?
a very big
You
difference.
asked that question. Was this a business related to, how was it related to your business? Was it a family member, etc.?
I would have loved to, Your Honor, except that counsel for the husband.
Except that you didn't. You went
you know,
into
this-
asking specific names.
You chose to focus on the paramour issue, which is why you kept on getting stopped.
Right, except that I think that without knowing the nature of the relationship, let me see if I can
Counsel, you want to keep on, you can couch it in whatever way you wish. The bottom line is that what is relevant is the amount of money that has been wasted from the marital assets, not to whom.
Okay, so in that case, it was a procedural defect because trial courts don't have judicial fiat authority to decide respectfully what questions can be asked. That's why the legislature enacted the deposition.
Who has? I'm sorry. So who has the? So who has the right to decide? You?
Well, no, but the trial
But
court.
then who has the right to decide?
Actually, this court has the right to decide.
No, the trial court has a right to make rulings on discovery matters on proceedings before them.
Right. So I respectfully submit that this was a gag order that prevented the wife from even getting to the questions.
Counsel,
of
here's the
marital waste.
problem. Here's the problem.
Yes, Judge.
The court said on more than one occasion, this is not about romance. This is about the money, which is what my colleagues keep saying. This is about the money. And even now, you are still saying the same thing, which is the equivalent of open up People magazine and let me know, who you were dating, what their names were, how long you were going out with them. What does that have to do with the issue of marital waste? Your questions could be focused very narrowly so that you fall within the contours of the court's directives, but your position is the court doesn't matter. Only the appellate division matters.
Well, not exactly, except that if trial courts have the ability to constantly control the amount of discovery, then why did the legislature issue the deposition?
That's what the trial courts do. I'm not understanding exactly what your argument is.
Well,
Perhaps you want to move on to something else.
Okay.
You don't
Like
think
the
that the
fees.
legislature is going to make a ruling on whether the question is permissible or not, do you?
No, I understand, but I'm going to move on because
You want to talk about the fees?
I'm sorry.
Fees,
the money.
the $25,000 that was the trial attorney's fees.
Could I just, before the counsel fees, there's just one other substantive issue, which is that the trial court, motion court, excuse me, decided that questions asked of the defendant husband's extended family, in particular his mother, who is wealthy and owns land and things in Mexico, were improper and
And why did the trial court make that determination?
I wish I knew, Your Honor,
Well, I
because
thought the
there's
trial court said because that wasn't considered a part of marital property. And
Exactly.
was not relevant.
It wasn't just, you know.
So there's no reason for you to wish you knew the reason.
Right,
Yeah,
it
no,
was
well-
based upon the facts.
Okay.
It was
Well,
based
no,
upon the relationship.
I totally disagree, Your Honor, respectfully. The facts
So
of this,
what does the husband's mother's status, financial status or assets have to do with the husband?
it has to do with DRL 3 sections which permit
So
questions.
should the
of-
husband get information on the wife's mother's assets since she has enough to pay for the attorney bills? Should he also be entitled to know how much money she has?
Absolutely.
How much property she has? How much money her daughter stands to inherit when she dies? Because that's what we're talking about. Until there is a transfer of monies because of a bequeath following a death of a parent, it seems to me that all of that is speculative.
Okay,
Right?
well, I did a fair amount of research on this case, Your Honor, because I anticipated these sorts of questions, and what I will stick to respectfully is this. We have 3 sections of the DRL that say, you can do this. What can you do? You can examine on the overall scope of a party's finances. There's case law allowing...
So a parent's finances become your finances.
No, they don't, Your Honor.
Well, that's what you're saying. You're saying that the wife is entitled to invade the privacy of her mother-in-law and find out all of her assets, all of her property.
It's not what I'm...
In the event that when she dies, her husband might inherit some of that.
Okay, well,
So I should be able to know all of your business today while I am seeking a divorce from your son. That's what you think the law requires?
well, Your Honor, I think what the law requires is adherence to DRL 236b-5, which allows 16 factors. Factor 9 is the probable future
All
financial...
right, I'm going to let you go through those 16 factors on your rebuttal time because we are out of time.
Okay, can I just briefly...
When you have rebuttal, you can go through those factors.
I was asked a question by Justice
Counsel?
Gonzalez.
I'm in control of this panel.
Yes, Your Honor.
Please have a seat.
Yes, Your Honor.
May it please the court. I will keep this very short because I believe from your comments so far, your honors
Counsel?
understand the issues.
Do not.
Understood.
Don't make that mistake because you're going to get the devil's advocate now.
You're right.
Go ahead.
The issues that really are before your honors is whether the appellant wife is entitled to expand.
Well, if your client if there are expenses that show the other side that your client paid for 30 flights and they have no way of knowing who those flights are for, why isn't that proper discovery in order to ascertain what part of those expenses were appropriate and what part of those expenses constitute marital waste? Why cannot the other side ask enough questions about the identity of the people on those planes in order to try to ascertain who's a business person, who's a friend, and who's a paramour?
The issue is the other side didn't ask those questions. They kept asking, are you dating someone? Let's talk about your girlfriends. Had they focused on the actual amount of money spent and simply said, was this a business trip? Was this a personal trip? Who went with you? That would have been one thing.
Without identifying the recipient by name, how do you discern the accuracy of the information that's being provided?
There's no issue with the appellant having asked, what is your relationship to that person? They didn't do that.
So there were no expenses presented wherein the appellant said, these are expenses for flights. Is this person a paramour or was this a business trip? Is that what you're saying?
Correct,
There were open-ended questions regarding, are you dating anyone?
They were open-ended questions, and when my client was
Not coupled with any financial records.
correct, but when my client was
But
asked,
opposing counsel had financial records showing what expenditures were made.
correct,
So it was a question of identifying what those expenditures were for.
it was, Your Honor. However, when my client was asked specifically what expense a certain amount was for and who it was for, he answered those questions. And I think that that's what the appellant is failing to recognize, that when my client was asked financial questions about what he spent the money on, he answered all of those financial questions. So their allegations of marital waste, they still have to prove that at trial. But my client answered all of those questions.
Okay, counsel, with regard to the fees, is there any reason why we can't increase the fees that were provided to the appellant, given that your client has paid substantial amount of fees to your firm?
Your Honor, the appellate division has had many cases where they have given great deference to the trial court, as the trial court is in the...
That's true, but answer her question. Why is it that your client can have his fees paid, and your firm get paid without a bump in the road, and she should have to borrow money from her mother in order to fulfill her obligation?
Given the fact that it is undisputed that she is the less moneyed spouse.
Your Honors, the wife has also used substantial marital monies to pay for her attorney's fees.
She claims that she has had to go to her mother and family members in order to pay the fees.
And yet, there are records showing that she has used the party's joint bank account to pay her attorney's.
Does the record contain any indication as to why the trial court only awarded $25,000 in fees?
The decision from Justice Katz specifically says that he has taken into consideration, I apologize, just bear with me. The decision specifically says,
well, we read it.
But he had taken into consideration the history of the litigation and the financial circumstances of the parties, and this is most important, and specifically the disparity in the parties' income and their respective abilities.
And the judge thought that awarding the less moneyed spouse $25,000 for legal fees when your side has paid $240, that's fair and that's equal.
Your Honor,
that's proper.
Your Honor,
from the marital money.
I also think that part of the reason that the award was $25,000 was because the appellant made a motion that the judge had asked the appellant specifically not to make.
Does the decision mention that?
It does not, Your Honor.
Was that on the record?
That the
judge had specifically asked not that motion shouldn't?
Yes, Your Honor. At the July 24th, 2024 appearance, the judge specifically said to appellant, do not make a motion trying to ask more questions about romantic partnership.
So this was almost a determination. It seems what you're suggesting is that this was some type of determination that the attorney's fees or the fees requested were out of line and were too high, and that the attorney was doing work that should not have been done and therefore asking for these monies?
Correct, Your Honor.
The total amount of counsel fees awarded to the wife is $25,000?
It was $25,000 in this order. There had been a previous pendente lite order awarding her $20,000.
So a total of $45,000.
And my client also paid an additional approximately $6,000 pursuant to a stipulation.
You say that the wife used marital assets to pay the attorney's fees. Does the record establish that the marital assets were used to pay the attorney's fees?
Yes, Your Honor. There are
before us.
Where is that in the record that she took out money that you can show through documentation that money went directly to counsel?
And is that in the record, or did the motion court consider that?
I'm not sure if the motion court considered that, Your Honor, but the court did, in the pendente lite order, recognize the monies that the wife had taken out from the marital assets, and those records are in the, I apologize, those are in the record.
And how much was that?
Let me just find that information. Give me 1 second. I apologize, Your Honor. I
All right.
can't find it right
Thank you.
right away. Thank you.
Your Honor, even
Did
if the,
did the wife
even if
take
the,
marital assets to pay attorney's fees?
I'm sorry, sir?
Did the wife use marital assets to pay attorney's fees?
I was just about to address that. The wife did take approximately $70,000 from a joint bank account to pay counsel fees with. However, that is going to erode whatever equitable distribution she has. It's a common, I've found this a common mistake in the case
Counsel,
law.
is it accurate that the court only awarded the $25,000 because you made a motion that the court directed you not to make? Is that a
No,
part of the
that's
rationale
inaccurate.
as to why
That is
the award
inaccurate.
was so low?
I apologize. Well, I don't know the motivations of the motion court, Your Honor, but I know this. The motion courts, in effect, said, it's in the record, basically, don't you dare file a motion that's going to allude to your ability to ask soap opera questions. The reason I was not even able to get out a allegedly soap opera question was because
Isn't it clear that the court did not want you asking questions about the paramours, and the court did not want a motion on that subject?
no, what was clear was that
It was not clear that the court did not want you to ask additional questions concerning a paramour?
no, it was not at all.
Well, it was clear to me in reading the record.
Well,
I think, I don't understand what, well, it was clear to me.
Yes, I thought you made a distinction,
Okay,
if I
what
may,
was
between
trying
counsel, between a written order from the court and a directive issued orally from the bench.
My understanding with regard to both the bench order and the written order of February 7th was that I was not to ask salacious or soap opera type questions. I never did.
When you ignore the court, you come here and expect us to do what? To undermine the exact directive of the court?
No, absolutely not.
Court told you don't ask those questions.
I understand, Your Honor.
Don't submit a motion because I've already told you that's not allowed. And you do it anyway.
Well, I didn't understand that was the court's intention.
How could you not understand that? The court said, don't file the motion. I mean, how much plainer does the court have to be?
Respectfully, Your Honor, what the trial court said, what Justice Katz said was, don't file a motion and
Okay,
don't
that seemed
ask
kind of
questions.
clear to me.
Regarding soap opera, may I respectfully, I'm not going to ask a rhetorical question. I don't know what the English language translation.
Oh, you didn't know what he meant by soap opera, right?
I didn't ask any because counsel kept instructing her client.
Yeah, see, obviously this is the problem. And I see now what the problem is, but whatever.
Last thing
you.
else.
Thank you.
Thank you, Judge.
DH 336 Partners versus Sentinel Real.
Speechless. Oh, my God.
You may proceed, counsel.
Good afternoon, Your Honor. It may please the court, Antonio Perez Marquez from Davis Polk and Wardwell for defendants appellants. The IAS court below made 3 clear errors of law that require reversal of the order denying our motion to dismiss. Time permitting, I'd like to address all 3. The first is with respect to the statute of limitations. This complaint was filed in 2023, alleging a scheme to illegally deregulate rent control departments. The problem is that in 2019, 4 years earlier, there was a complaint filed by the Attorney General that alleged the exact same scheme against one of the defendants in this case, David Drumheller. It alleged that acting as an agent for owners, including my client Sentinel, he illegally deregulated hundreds of apartments. One of the buildings at issue in this case was used as an example. Now, they concede, it's record page 494, that that complaint alleged, quote, the same illegal activity. They have alleged in their complaint, as if that were not enough, that the 2019 Drumheller complaint makes clear that Newcastle, the property manager, as agent for Sentinel and its affiliates, defrauded plaintiffs. They've alleged the 2019 complaint makes clear they were defrauded. And as if that weren't enough, the Attorney General in 2019 emailed the complaint to them, pointing out this impacts your properties. Now, the standard is inquiry notice, whether the circumstances are such to put someone of ordinary intelligence onto the probability that they had been defrauded. Justice Boddy in Brooklyn, confronted with a parallel case raising identical issues, dismissed, applying this court's precedents in Ambach and Azora. Now, the IAS court said the Drumheller complaint isn't enough because it had a different focus. That ruling is completely at odds with Ambach and Azora, this court's decisions, which make clear that even similar allegations are enough to trigger inquiry notice. And in case there was any question about, well, the complaint was about Drumheller, they didn't sue Drumheller either. They sat on their rights for 4 years, and now their claims are untimely, and that impacts 3 of the 5 buildings at issue in this case. The second issue, Your Honors, is reliance. This impacts every claim, every building, every plaintiff, because in all the purchase contracts in this case, there was a disclaimer of reliance on extra contractual representations. Those disclaimers said that plaintiffs were accepting the buildings as is, that they had...
Does that pertain to fraud?
Absolutely, Your Honor.
Why?
Your Honor, this contractual disclaimer language is standard form language put out by the City Bar of New York. We have cited 7 cases.
Well, then that's it.
Your Honor, I will continue, Your Honor. We have cited 7 cases ruling on that exact language, all dismissing fraud claims. They have not identified one case in which a fraud claim has survived in the face of that disclaimer language. And it's not just the 7 trial level decisions that pertain to that exact same language. It's also this court's decisions. We have cited...
I looked at this from the perspective of inquiry notice. At what point was there an awareness that fraud was going on, alleged fraud was going on? Is it at the point where the AG initiates an action and a copy of the complaint is sent? Is it at the point where there's a resolution by way of a stipulation of discontinuance that outlines the fact that there is an agreement as to what the alleged wrongdoing was without any acknowledgement, formal, you know what a stipulation of discontinuance is, within the context of the AG? You can say, I don't take a position, yay or nay, but I'm going to pay so much money as a fine, as a penalty. I'm going to rectify this and that. At what point is there inquiry notice? Because that really falls hand in hand with the issue of the fraud claims and whether you can say that there's justifiable reliance or that that's been waived, at least in my brain.
Well, yes, Your Honor. Respectfully, I think it's 2 different issues. On the limitations issue, the direct answer to Your Honor's question is that inquiry notice arises when the complaint is filed. That's what this court's decision in Ambach stands for. Public complaints, particularly in this case, a well-publicized complaints, that suffices for inquiry notice. Now, that is distinct from the issue of the sufficiency of the disclaimer. The disclaimer, which disclaimed all extra contractual representations, that precludes...
Representations here also involve a matter of public record, a reliance upon what the public record shows as to the rent status of these apartments, and how does that interplay with the disclaimer?
Well, the disclaimer, Your Honor, is that they are not relying on anything outside the 4 corners of the contract. So whether...
Except we know that in performing due diligence before buying a building, these entities absolutely go outside of the documents necessarily inside, within the company, and they go to the public filings with respect to the rent and the increases over the time, et cetera. So we know in this context that there is reliance, certainly at the entering of the agreement. You can't do due diligence on these cases without a review of these public records. So why is that statement accurate in this context?
The public records are not statements made by the defendants.
Yes, they are. Those are records made by the building owners, right?
To the extent, Your Honor, that they're made
They
outside.
filed them. They have a duty to keep them. They are required by a statutory regulation to file them and keep them up to date. So they are absolutely statements that came from the defendants.
I should have indicated, Your Honor, they're statements outside the contract. And here, the disclaimer is they're not statements by the defendant inside the contract. And if I may, very briefly on the last issue of standing, Your Honor, because here the court made a crystal clear error. There are 7 of the 8 plaintiffs in this case did not receive the misrepresentations at issue.
Sure they did.
They did.
They were all one and the same, right? The entities that all of these purchases were created by LLCs that were intended to buy these buildings, et cetera. This is normal, standard practice in the industry that when companies are going to buy a building, they create an LLC in order to park the property into that investment. So that is normal, and that's exactly what happened here. So the very same people who were across the table in the signing are the same people today. They're not different.
Your Honor, the law that this court has issued, such as in the Ames decision, is that in order to have standing on a fraud claim, you must receive the misrepresentation. The misrepresentations they allege are during the due diligence phase, before the signing of the contract. 7 of the 8 plaintiffs didn't sign those contracts. They came into the picture after that. Now, fraud claims in New York are freely assignable. They could have assigned the fraud claims, but they didn't. The fraud claims were not assigned.
What language was missing? They said all of the interests.
They said all right, title, and interest. That's exactly right, Your Honor, and that's precisely the language that this court in Dexia and Royal Park and California Employees Retirement System said that language does not transfer fraud claims. The Court of Appeals has said the same in the Commonwealth of Pennsylvania case. So the court made a crystal clear error. It found sufficient language that binding appellate cases said does not transfer fraud claim. Under the Court of Appeals authority in Commonwealth of Pennsylvania, fraud claims, yes, are freely assignable, but the contractual language must evidence a specific intent to transfer them.
Before you go, I want to take you back to the disclaimer. Aren't the representations that we're concerned with here matters which are peculiarly within the defendant's knowledge?
No, they're not, Your Honor. They have admitted that the facts, the documents, the information on which the Attorney General relied to bring their Drumheller complaint, which again is the exact same wrongful conduct, according to them, the same wrongful conduct, they admit, page 51 of their brief, they don't dispute that they had that information. And what information is it? It's IAI checklists, renovation checklists, the same documents that, as members of this court know very well, those are the documents on which parties rely when they're challenging rents for allegedly miscarriage.
Yeah, but looking at bills that were purportedly paid for renovations is not ironclad proof that those renovations actually took place, right? There's no way looking at those documents to know that.
Well, again, Your Honor, these are the documents on which the Attorney General made their case, but the standard for peculiar knowledge is not ironclad proof. The standard for peculiar knowledge, this is a narrow
The Attorney General made its case on that because they got behind what Drumheller was up to. Is that something which is in the ability of someone else doing due diligence to figure out?
Absolutely, Your Honor, because
So you're buying a building, you have a building that the seller is saying, we have deregulated 15 of the apartments in this building, and here are the records for the deregulation. So you're saying that a proper buyer, to exercise proper due diligence, should now take all 15 of those deregulated apartments, go through each and every one of the contract bills, and do an investigation to make sure that the contractor came with the drywall, that the electrician came and did the electrical work. That's what you're saying.
The issue, Your Honor,
And I don't think that our case law or anything in our jurisprudence requires that.
the issue, Your Honor, is not the sufficiency of their diligence. The issue is whether the topic.
Isn't the issue Drumheller was engaged in a criminal scheme, whether this is something only the defendants could have known about or something that the plaintiffs could have figured out?
It's whether it related to something that they did not have the ability to discover. And if you look at the cases that actually find the peculiar knowledge.
But counsel, so the AG's complaint did not encompass all of the buildings at issue here, right? It encompassed some of the buildings.
It used one of those buildings as an example, and I would just note.
No, but one. So I go back to my question way back when, which is the import or how we define inquiry notice, what inquiry notice had to be made here. If one building is ¿cómo se dice? Destacado. Highlighted, emphasized, set forth. If one building is identified, and I happen to own 4 buildings that this person also, or company also has, that's supposed to mean that I have to make inquiry and make sure that there's no fraud as to my 4, understanding that I do not have access to all the information that the AG's inquiry in what could be a criminal investigation could undertake?
Absolutely, Your Honor. It's more than enough. And if you look at the Azora case was a case against Credit Suisse, and it found that a prior case against Citibank relating to a different collateralized debt obligation.
Those were in RMBs, right?
RMBSs, yes, Your Honor. It was CDOs, packages of RMBSs. And it found that.
A little different than what we have here.
But
right?
the important point, Your Honor, is that in terms of how on all fours do the public allegations and the current complaint need to be, in that case it said, look, this is allegations against a different party. There was a prior complaint against Citibank. You bought a CDO managed by Credit Suisse. The Citibank complaint is enough to put you on notice because they had a party in common. So not the fact that there was one building that they bought that is given as an example, it's not only sufficient, it's more than enough. If that building hadn't been mentioned, the fact that there was an allegation of a scheme that the property manager of the buildings they bought was engaged in a widespread scheme to illegally deregulate, that on its own is enough. Thank you, Your Honor.
Good afternoon, Your Honors. May it please the Court. Leah Kelman for the plaintiff's respondents. I'd like to address each of the 3 issues that my colleague addressed. First, the timeliness of our claims. I'd like to first emphasize that 2 of the plaintiffs and 2 of the buildings are undisputedly timely, and there's no issue about that. So we're only focused on inquiry notice with respect to 3 of the, well, there's multiple plaintiffs with respect to one of the buildings, but 3 of the buildings. My colleague pointed out that the Drumheller complaint was filed in May of 2019. The only building that was mentioned in that complaint was a timely building. I'm shorthanding the plaintiffs and the buildings. I'm United Interest.
Why would that, I'm sorry, if I own buildings and I have a manager and the AG files a complaint against my manager, I would look at everything. Everything that this manager touched, I would want to look at. So why were your clients not on inquiry notice to at least look?
Yes, so each of the transactions were separate transactions. They did not happen at the same time. It was not the acquisition of a portfolio.
That's not the issue. The issue is we have a fraudulent player. So were you entitled to believe, oh, he was only fraudulent with this one place? not the rest of my stuff. I mean, I don't understand why the alarm bells didn't go off.
The alarm bells didn't go off until we got notice from the Attorney General that we were required to re-regulate units in each of our buildings, because that was the point at which we suffered a loss. And
So you had to wait for a loss to see if there was something wrong with this manager who is being prosecuted by the Attorney General's office for conduct that I've hired him to do for my buildings?
Right, it's the same conduct. That's what I'm not understanding. I mean, you're hiring him as a manager, and you know that in the context of his managing this other building, he engaged in fraudulent activity. So why wouldn't you think, well, you know what, if he managed that building fraudulently, engaged in fraudulent activity, maybe he's doing the same with my buildings.
maybe he did. So the Drumheller complaint.
So that maybe he did, should you not then have made some type of investigation, undertaken some type of investigation?
2 points on that. The reference that the identity of the 336 property in the Drumheller complaint was an example is not clear from the complaint. The complaint says that there was widespread fraud for deregulating hundreds of units. And then it goes on to list at least 8 properties in which this happened.
Do you know the name? It's the same, the name is there, right?
The
You know the individual.
Yes, the individual who was the property manager for
Exactly.
Newcastle. Yes. So I think that with respect to those 8 buildings that were listed, I counted 8. That's just my manual counting of the properties in the complaint. With respect to those 8, I think it's reasonable for a person of reasonable, ordinary intelligence to think that there might be something to look into. With respect to the rest of the buildings.
But only as to those 8?
Well,
You're saying that the red light only went on for those 8? That it did not dawn on your clients that it would behoove them to look at all of their property interests and make sure that this person that they had hired was operating on the up and up, and that your company would not end up on the tail end of another AG investigation? They didn't think it.
This property manager did not work for us.
But he worked for the company that your client employed, right?
No. My client is the purchaser of 5 buildings. Drumheller worked for the previous owner, the property manager of the previous owner. And no time did he ever work for us.
Right. So he worked for the previous owner of buildings your client bought.
Yes.
Right? And some of what your client bought was buildings that had allegedly properly deregulated apartments, right? And you have a complaint saying this person engaged in fraud in deregulating apartments, and there was no connection between those 2.
There is no connection between our 1 building and the other 4
So
transactions.
were you aware of the fact that he worked for the prior owners?
The complaint says that he worked for the prior owner.
Okay, so you knew, so you were aware of that?
Sure. Yeah, I can't dispute that, but I also think.
Why doesn't that convey inquiry notice on your clients if they purchased the property from an individual or a company that hired this person who had been committing fraud?
My client purchased property from a seller who had a property manager who had committed fraud on in certain buildings. So
are you trying to confine the fraud only to specific buildings and saying because it was only those buildings, there was no obligation to look into it in general?
I think that on an inquiry notice, which is a mixed question of law and fact, and there has to be a probability of fraud with respect to the other buildings to trigger the inquiry notice. I don't think you can discern a probability of fraud on a slate of an entire portfolio. Sentinel and its affiliates own, I don't know how many buildings they own, but they're $9 billion under asset. They manage $9 billion worth of assets. So they have hundreds of units under management.
Is it based on a slate of buildings, or is it based on the conduct? That this conduct occurred that could have put a person of reasonable, ordinary intelligence on notice that they should look into it?
I think it's a mixed question of the conduct and the buildings, because again, just because there's a tie from one building to the conduct doesn't mean that that conduct occurred on other buildings. But I would also like to add something that one of your honors pointed out, which is that the discovery of this fraud was simply through a criminal investigation involving subpoenas that
Nothing simple about a criminal investigation, counsel.
exactly, which is why it would be difficult for my client.
And you get it handed to you on a silver platter in a report, and your clients do nothing with that. We got it. Thank you.
Very briefly, Your Honors, just on the limitations issue, my colleague repeated an error here, which is the idea that all the elements need to have taken place in order for inquiry notice. They needed to wait for damages. That's not the law. And one fact, which is very significant that was not mentioned, is not only did they have the complaint on a silver platter, it was emailed to them by the Attorney General. You should take a look at this. Will you consider staying evictions and taking action with respect to rent, with respect to the buildings you purchased? They didn't even have to connect the dots. They were connected for them.
Does the concept of finality come into this at all? That there's no inquiry notice required until there's finality as to the AG's, not the investigation, but the litigation, the prosecution?
Absolutely, Your Honor. No finality is needed. They don't need to wait for it to end. The public complaint itself, the press reports, the emailing of the complaint to them by the Attorney General, that is sufficient to trigger inquiry notice. I wanted to address briefly the peculiar knowledge because I didn't get the chance to finish answering a question before. The issue with peculiar knowledge is that it is a narrow exception to the default rule, which is that—
Sorry, you're saying imputed knowledge?
Peculiar knowledge.
Peculiar
Your Honor.
knowledge.
Yes. Excuse me.
Thank you.
Yes, so peculiar knowledge. This is on the issue of the disclaimer. There is a disclaimer in this case that they're not relying on any extra contractual representations. Those disclaimers are enforceable under New York law. They preclude reliance. There's no representation on which for them to rely because they agreed, we're not relying on any extra contractual representations. There is a narrow exception to that, which they're trying to invoke, peculiar knowledge. Now, peculiar knowledge is not justifiable reliance. It has similar tones, but it's not the same standard. It's a narrow exception. And so what you have here is that what they allege was misrepresented, what they allege should not be deemed covered by the disclaimer pertains to the rents of these units and their regulatory status. They've admitted they have the documents that support the IAIs. They had those.
But I don't understand, if there were kickbacks in place and how do they get to the bottom of it? Where does the inquiry go? They don't have the information that the AG has.
Well, they do, Your Honor, and that's exactly the point that they're not disputing. They just, page 51 of their brief, they don't dispute the proposition that they had the information that the AG had. And so now the question is that—
I'm struggling with the issue, though, but if there's a criminal scheme, what Drumheller did is a criminal scheme, how could having those documents help them? I mean, if there's a kickback going on, how are they going to know about it?
The issue is whether the topic is a topic that's exclusively within defendants' knowledge. And the cases where you see that found to exist, like the TIAA case, structural defects that could only be identified through destructive testing. Or in the Tahini case—
I suppose your client's position has to ultimately be we're as much a victim of Drumheller as the plaintiffs are.
Well, that's a fact. I mean, the AG said as much in the Drumheller complaint. It said that buyers of these properties overpaid for them, and the owners were victimized as well, the existing owners like my client. But it requires more. The peculiar knowledge exception is not per se satisfied in a fraud case. Yes, they allege that they were defrauded. That's not enough to invoke peculiar knowledge. The subject matter of the alleged that they say have to say is exclusively within our knowledge. They don't dispute they had that information. They have not pled what they need to plead in order to invoke peculiar knowledge, and for that reason, the disclaimer must be given effect, and all claims dismissed. Thank you, Your Honors.
Thank you so much. All right, Maduri versus Montefiore Medical Center.
Good afternoon, Your Honors. May it please the court, Scott Horn, counsel representing the appellant in this matter. It's our contention, Your Honors, that the motion court erred in granting the defendant's 3211A7 dismissal motion based upon the affirmative defense of EDTPA immunity. As in this court's decisions in Holder and Jackson, defendant failed to conclusively establish that, quote, and I'm quoting from Jackson, all of plaintiff's treatment, in this case over the course of 2.5 months, was impacted by the defendant's response to the pandemic. We submit that these cases mandate reversal here because, as in those cases, defendants' conclusory allegations regarding short staffing and operational changes are insufficient to support a 3211A7 dismissal.
So those cases are factually distinguishable, no?
Well, after my last appearance last week, I went back and looked at them. I'm getting a sense of deja vu right now. Actually, in Jackson, I think it was, so I think what part of the conversation that we had was the timing, and that this was the height of COVID, and this was late March, early April. As it turns out, in Jackson and Holder, one of those plaintiffs was involved a situation where they went into the hospital a week earlier than my client, in this case, and one of them was a week later.
Well,
So
it's not just the timing, right? It's in one of the cases, I believe it was Jackson, it was failure to provide a walker that was at issue.
That's right.
Right? And
Yes.
that's not what we have here, right?
Well, we have a second piece in Jackson also. So the second piece in Jackson was a defendants experienced short staffing and overcapacity limitations due to pandemic, and this was impacting the ability to supervise, monitor, and aid the plaintiff. And that was literally the point that I was trying to make last week when I was here, which is that this court's precedents recognize that we're gonna look at the individual claims in applying the EDTPA. Jackson is a perfect example.
So it's different from the Jackson court did not find it a proper reason or sufficient reason to not, that COVID was not a sufficient reason for them not to have just simply brought in a walker into her room so that she could go to the ambulate to the bathroom.
Which is what happened, right?
Right?
But
So that's different from I am intubated and I must be in order to save my life, and my physical the specifics of my physicality make turning me and repositioning me difficult and potentially dangerous. So those were the issues kind of we explored last week.
Oh, that
and
was
for the
so much
benefit of
fun.
your co-counsel who wasn't here and wasn't on that case.
I found out
it's
she
the
was
same,
watching.
And it's the same as what we have here, right?
Yes, no, it is. And so this case mirrors the case that we were on last week. And the point that I would make, if I may, in response to your question, to your point, is that the walker was part of it, but there was also this concept of failure to supervise, monitor, and aid,
Right,
which
but
is
she,
precisely what
in
we're
Jackson,
talking about.
come on, it's the walker. She fell.
Yes,
right? Because they didn't give her a walker. So those two were intimately tied to that particular injury.
That is correct, Your Honor. I'm not saying that Jackson is directly factually on point, but the logic behind it and the law that's putting into place is the law that I'm advocating should be followed in the adjudication of this case.
Got it.
Thank you, Your Honor.
And apologies, counsel, for that repartee. It's a very similar case to the one we had before.
I was watching it. My
Okay,
office
so
is
you know.
somehow involved in that case. Good afternoon, Your Honors. Catherine Herr-Solomon on behalf of Montefiore Medical Center. The trial court properly granted.
So why isn't the affidavit submitted here conclusory?
Nurse O'Brien's.
Yes, Nurse O'Brien's affidavit, her affidavit seems to be, in essence, right? She states that COVID-19 created staffing issues, reduced prioritization of skin care, patient care rendered in good faith, overwhelming challenges, documentation was relaxed, there was certain triage to treat certain patients. Why is there nothing in her affidavit which speaks directly to this patient?
So I would point to her deposition testimony, which was more detailed.
So does that speak directly to this patient?
It spoke to the unit that this patient was on, 5N, which was a telemetry unit that was converted to an ICU, and it contained at least 30 COVID patients. And an ICU, typically the nurse-to-patient ratio is 1:1 or 1:2.
Does she talk about that in terms of this unit, in terms of what the ratio was?
Yes,
It's 1 to 10, right?
I think, if you look at her deposition testimony, it's not very long, but it paints a very clear picture of what the hospital was like at this time.
So other than the ratio, does she talk about anything else in terms of the care of this specific patient and why COVID affected it?
She talks about the unit in general, that the nurses were responsible for significantly more patients. They were responsible to take care of patients that were mostly ventilated, which requires a higher level of care and necessarily takes up more of their time.
And all of the nurses that were in this particular unit were not originally ICU nurses. Each of them had to be trained when they created this makeshift ICU unit.
Exactly, right. And Nurse O'Brien testified that they were constantly interrupted by codes. So even if your patient isn't coding, if a nearby patient is coding, they're all supposed to help and aid that patient. So when you look at all of those factors all together, it's clear that this patient and all of the patients at that time, their care was impacted by the hospital's response to the COVID pandemic.
So is there a distinction with respect to the plaintiff's comorbidities and the patients in Holder and Jackson?
I would argue that that Holder and Jackson are not applicable to this case at all based on the procedural posture. But I would also argue that there is a direct link here between the nurses necessarily not having enough time to turn and position every single ICU patient. There are 30, and their ratio is 1 to 10, and you combine that with the comorbidities. This patient was obese, so it would likely take more than 2 nurses to turn and position each patient. There just simply wasn't enough time. They were focused on saving these patients' lives.
To the extent that the comorbidities existed, and in particular, I'm thinking of the weight as well as the diabetes. Those two would be known factors with respect to the development of ulcers, right?
Exactly.
Nurse O'Brien said that this patient was at a high risk of developing ulcers, and that ultimately a judgment call was made that the ulcers kind of were on the low scale, and the saving of lives per se was on the high scale. Would you characterize those actions as that judgment call as gross negligence, understanding that there were special protections for the hospitals and their staffs during COVID pursuant to the governor's executive order?
Right. It was definitely not gross negligence. First of all, plaintiff concedes in the bill of particulars that they are not alleging gross negligence.
Is gross negligence alleged in the complaint?
I'm not sure.
I don't believe it is, but I believe that the doctor for the plaintiff uses the term gross negligence, and that's the only time that it's really referenced.
Right. There is no gross negligence in this case. That decision was a matter of life and death, or an injury that ultimately healed. So that is not gross negligence, and so there's no exception to the EDTPA application here. And plaintiff's expert ignored the circumstances of the pandemic and didn't mention them at all, and didn't offer an opinion as to the PJI says that you have to have a departure under the circumstances. You have to depart from accepted practice under the circumstances. The circumstances here were not your typical circumstances prior to COVID. So his opinion was irrelevant, and it doesn't change the fact that EDTPA immunity was properly applied here.
So, counsel, I know you made reference to the fact that she was obese and therefore it would be difficult to turn her. Did Nurse O'Brien testify that it would it would require more than one nurse or one individual to turn her?
I don't believe she testified to that, but just logically, I know this patient weighed over 200 pounds, and she's attached to a lot of tubes and wires. So Nurse O'Brien did testify that it was difficult to turn and position a patient like this who was attached to a lot of tubes and wires. And you could, shift the tube, and all of a sudden she would be, lacking oxygen.
Thank you.
There was discussion about the fear that repositioning could cause a drop in her stats,
Right.
such that it could create an emergency situation.
Right. Thank you.
Thank you. Counsel, you have a minute.
Very briefly, Ryan, I just want to touch on 2 points. The first thing is that the conversation here today seems to underscore the fact that it's generalizations. It's nothing specific to this.
Well, that was my question,
patient,
because
right.
it does seem to be specific to this patient in terms of the ratio of attendees, medical personnel to the individuals, 1 to 10, in terms of the care necessary, in terms of turning her, the fact that she was incubated, et cetera. So there seems to be specifics as to how COVID specifically affected this patient.
So the specifics are to the unit or the unit within the hospital, not to the patient. So when you say turn a patient, yes, that's what the testimony was. It was not turn this patient.
It was
the
turn this-
unit in, I'm sorry.
Go ahead.
It was the unit in general. And it's those
But
types of.
Counsel, that's not exactly accurate, because in Holder, which is 2024, the court determined that, we determined that a motion based on former Public Health Law 3082, the COVID immunity statute, must conclusively establish the impact on the treatment of the individual, the treatment
Exactly.
rendered to the individual.
That is
And-
exactly
and a
my
fact
point.
Intensive inquiry is required.
That's exactly my point, Your Honor.
Under
Yes, that's.
Otherwise, you get dismissal under 3211A7.
If I may address that. So I actually wanted to point out the portion of Holder that I think is truly important here. And that is the part where the court talks about how the affidavit submitted by the defendants describe, quote, numerous and pervasive systemic changes to hospital operations, and that they suggest that this particular patient's treatment was impacted, but suggestion, this is a quote, suggestion is not conclusiveness. And that is exactly the point that I've been trying to bring home here today with regard to this case. And if there are no further questions, I'll be happy to rely on my briefs.
So in light of the legislature's decision to relax note-taking, and that is normally the way that a hospital would be able to controvert these type of claims.
Right.
What do we do with that? They didn't have to take notes because the government decided it's more important that we don't want you standing on the corner taking notes. We want you actively saving dying patients, right? So what do we do with that, right? You're saying, where's the evidence? Well, they weren't required to record the evidence. So all we've got is this is what we were dealing with, and this is how we managed it, and it is not insignificant to say that typically on an ICU ward, it's 1-to-1. Worst case scenario, 2-to-1. We had 10-to-1.
So even that, if you look at the way that that is phrased, so this is 2.5 months of treatment, and all it says is that at some point during this time, it was 10-to-1, not over the entire time. And again, we're still talking about generalities, not this specific patient. And the last point that I would make on that is with regard.
We can't make assumptions about what that translates to.
That's
if it takes one nurse for every ICU patient, worst case, one nurse for every 2 ICU patients, to cover them properly, then how can we ever say that, let me finish.
I'm sorry, I thought you were.
How can we ever say that a ward that was operating one nurse to 10 ICU patients, that it could possibly have been enough?
The response to that is where we are in this case, that the evidence needs to be interpreted in the light most favorable to the non-moving party. The non-moving party gets the benefit of the inferences, not the moving party, and that this is 3211A7 conclusively establishes the standard that was established by this court, clear, full stop. That's the standard. And so I agree, there's a tension there, but maybe the tension gets resolved further down the line and not on 3211A7.
Got it.
Thank you, Your Honors.
Palmer versus Woodside Ventures. I'm losing my voice.
I don't know why. It's not like you can talk.
You may proceed.
Good afternoon, Your Honors. Michael Dombrowski of Perry Van Etten for the appellate defendant Woodside Ventures. May it please the court, is Woodside's contention that the plaintiff in this action should have been held a special employee of Woodside?
How was the plaintiff a special employee of Woodside?
Sure, it's 2 separate issues. First, plaintiff was working for Woodside's alter ego management agent company, A&E, pursuant to the management agreement, which has been verified by Maggie Brune, who's a dual signatory of Woodside as well as the president of A&E. These are shared companies where Woodside delineated, subsidized, and controlled all of plaintiff's employment as well as his benefits, including insurance. Examples of that are Woodside delineated the exact hiring and firing guidelines for all porters, such as the plaintiff, the exact specifications of the porter's job duties, which are, quote, to further its interests in the agreement, whether the porters can enact any alterations or additions at the property, which Woodside would directly pay for out of a shared operating account.
So salary was borne by A&E, right?
Woodside set the salary and then paid it to A&E.
Well, they paid A&E for its services as a management company for the building, but was it delineated like this payment is for this employee?
Right, there's a whole comprehensive agreement where Woodside sets that and it pays for everything through the operating account, which is shared with Woodside and A&E. I'm sorry.
So plaintiff had an A&E uniform. He supervised through A&E property managers, right?
Correct,
The
but
agreement actually contradicts your position in that it provides that all the employees are employees of A&E, not Woodside.
right, but according to the First Department case law, a state
I'm going by your contract.
right in the
Right?
case.
So that's the first, and frankly, it stops right there. What does that contract say? And the contract says that all employees are employees of A&E, not Woodside.
And the Bautista in the First Department says that it's not the exact title, it's what the exact
So we should
agreement.
ignore the contractual language and substitute our own finding for the
Correct.
contractual language.
Correct,
And
Your
what case law says that?
as well as the alter ego relationship. Bautista had the case.
What's missing, counsel, is the nexus, the connection between this employee and Woodside. So
How did Woodside exercise complete domination and control over A&E's everyday operation? List them
They
out.
set who they could hire, what the workers could do, whether they could operate anything at the property.
Everyday operations.
Yes, Your Honor, in the agreement, as well as I
Where
was,
in the agreement does it say that it's exercising control over the day-to-day operations? What are they there for?
Right, it says that
they're-
A&E is doing that.
That's what Woodside hired A&E to do.
right,
So
and
they are not overseeing the day-to-day operations. That's what they hired A&E to
and as
do.
I know, their alter ego companies with a,
Well, you keep saying that. You're saying that doesn't make it so.
I can go through the reasons, Your Honor.
All right, well, you'll
Did
have
you have an
time.
agreement like this in Bautista?
I can check.
Thank you.
Good afternoon, may it please the court. I'm John Lavelle on behalf of Mr. Palmer here today. As the contract and the facts make clear, Mr. Palmer was not a special employee of Woodside. The important contract provision, the most important of all, it says, this agreement is not one of agency by manager for owner, but
They
one
say they say your company is their alter ego.
complete, the facts don't bear that out, Your Honor. A&E is a large company with over 500 employees, manages multiple properties. They have multiple divisions. They have a construction division, a finance division, property management division.
They own other buildings?
They manage many other buildings. And there's no evidence whatsoever that A&E or Woodside jointly or separately overlap in their ownership of different
Does
buildings.
Woodside work at every building that A&E oversees?
No,
Okay.
that's the
And
testimony.
Where are their offices?
Their offices are located in the same location.
Right, they
so
have joint offices, don't they?
they share the same space with an office building here in Manhattan. But when Mr. Eisenberg, the principal of A&E, testified, he could not testify who was involved in Woodside, who was the ownership of Woodside. There are many questions of fact in this record. And also, as Your Honor was saying before, for A&E pays the W-2, A&E pays the workers' comp, A&E
But they said that in the agreement that they set the payment schedule. Is that accurate?
set a payment schedule, but, so the example I used in my brief is when I go to a pizzeria, the pizzeria sets the price of the pizza, and theoretically, I'm reimbursing them for their costs, their materials, et cetera, but I don't control the kitchen staff in the pizzeria. It's very similar here. Everybody is limited by the contract and what the value is of their work, but that doesn't give them the requisite control. And again, if it was 3 employees co-mingling across both of them, they'd have better argument. In this case, they don't. A&E is a large company. You can't say that they're the same entity. They're just not.
Thank you.
Thank you very much, Your Honors.
A few points in rebuttal, Your Honor. Batista states, quote, the title of putative special employer, for example, managing agent, is not controlling, but the rather actual working relationship between the special employer.
The question wasn't about the quote, it was about whether there was a similar agreement as part of the facts of that case.
There are management agreements in these cases that are cited,
A
including.
similar agreement to the one here.
Is the language similar so that we can draw upon it in a
Right.
similar way?
And there's also case law even stating that the plaintiff's own realization of whether they're different companies or alter egos is irrelevant to the actual relationship.
And does the agreement say that the employees are employees of A&E and not Woodside?
Right, but as I'm noting, what it stated in the agreement is not.
Shouldn't we rely on that?
I'm sorry?
Shouldn't we rely on that statement?
I understand your point, but the case law says the contrary.
No, it's
It's
not.
based upon the
It's
actual
not my
relationship.
point.
Law says we have to follow contractual language.
And as if I can just
So
go.
I really don't understand that argument, that we should throw away the contract language for this case law that you seem to think trumps the contractual language here. But we will take a look at it, sir. Thank you so much.
And I just want to add one more point if I can.
Thank you so much. People versus Trevane Hilaire. You may proceed.
Good afternoon, Nusayba Hamad for Mr. Trevane Hilaire. Mr. Hilaire's plea was not knowing and should be vacated because the court misadvised him about his right to present a defense and told him that he could not call SEI in his case at trial. Preservation is not required.
Why is that?
Because here, Your Honor, there was no way for Mr. Hilaire to know that the information that he was receiving from defense counsel and the court was incorrect and then
What
moved to
made it
withdraw.
incorrect?
What made it incorrect, Your Honor, is that here, this was in the context of a conversation about Mr. Hilaire's reluctance to plead guilty.
The issue was, the claim here is that the court's statement that there would be no cross-examination of the CI was incorrect. What's incorrect about that?
So
Because the CI normally doesn't testify at trial, so there would be no chance to cross-examine. So what's incorrect about that?
the most incorrect thing was the court's statement that, quote, the CI is not of any relevance to the trial. This was a broader ranging conversation than just cross-examination.
But that wasn't the focus of the argument in the papers. The papers, you focused on the issue of that was incorrect statement. So I'm still trying to figure out what's the incorrect statement. That the court didn't think it was relevant, okay, perhaps the court shouldn't have said that. But what legally was incorrect about the court stating that there would be no opportunity to cross-examine
And
the
just so
CI?
we're clear, it was that the confidential informant was not relevant to the probable cause determination, but not, that it was relevant to the probable cause determination, obviously, right? But was not relevant to any trial issues, which is why I think that's correct. Is it not correct?
The informant would have been relevant at trial had Mr. Hilaire raised an entrapment defense under Goggins, as long as the defendant makes a motion showing that the informant was the reason that the defendant interacted with the police, and specifically is an active participant in setting the stage or performs a preliminary function in that interaction, the CI can be compelled to testify at trial. And the problem is not just cross-examination. This was a broader conversation. They talked about many aspects of the CI in relation to this case. They talked about cross-examination, they talked about credibility, but then the cherry on top is the court's incorrect statement that the CI is not of any relevance whatsoever. And in a case where Mr. Hilaire
So the defendant was seated in a car, and he had a .38 caliber pistol on his lap, right? And then he's removed from the vehicle, and the gun falls from his lap. And apparently there were 6 bullets in the magazine. And the reason that the officer approached was based upon the CI's information. Is that correct?
We contest the
I'm saying this is what the allegations are, that the CI imparted this information that someone was there at that location with a gun, and that's why the officers went to the location, saw the defendant with the gun in his lap. Is that correct?
No, Your Honor. The officers approached Mr. Hilaire, they removed him from the car, and then opened a bag that was inside the car and had the gun.
Okay, fine. My question is, how would there be an entrapment defense based upon that?
So Mr. Hilaire had the right to make a motion to present an entrapment defense, and as part of that—
But the question is, what reasonable view of the evidence would suggest that an entrapment defense was even viable in this case, based on the facts as articulated?
Exactly.
Sorry, could you repeat the question?
So your whole argument is that the court erred in stating that the CI's testimony would not be relevant at trial. Yes?
Correct.
So the question, and you stated that there are cases where if the defendant is setting forth an entrapment defense, the CI's testimony CI could be compelled to testify at trial.
Correct.
So my question is, how, under the facts as alleged, and we're assuming that these would be the facts that would be borne out at trial, how would the defendant be able to put forth an entrapment defense based upon these facts?
So again, it's about the CI's role in setting the stage for the interaction. And that role in setting the stage then creates an issue of fact.
Not as to entrapment. There's no entrapment here.
Your Honor, Mr. Hilaire had the right to present an entrapment defense whether or not, regardless
Only if that entrapment defense was reasonable under the facts, but that's not entrapment.
Does his statement at arrest that he found a firearm in a park in New Jersey go against your argument?
No, Your Honor, because those statements might have been suppressed, and we can't say what would have happened at trial. Mr. Hilaire had a right to present a defense. He could have presented an entrapment defense. He could have moved to
So at the time that the judge stated that that the CI's testimony would not be relevant at trial. The defense attorney then say, Judge, we may have an entrapment defense, and therefore it would be relevant, or you're incorrect because there's certain defenses that we could put forth wherein the CI would be compelled to testify at trial?
That is precisely the problem, is that defense counsel did not say that, and there's nothing in the record to show that defense counsel corrected at any point the on-the-record misinformation from the court. And the court did not say that the CI's testimony would not be relevant. The court said that the CI is not of any relevance whatsoever. And in doing so, it foreclosed any possibility to Mr. Hilaire that he could bring the CI into trial the way that he wanted to, and that the way that he could, or at least make a motion to. And under those circumstances, he could not have pled guilty knowingly without fully understanding his right to present a defense. And I'll leave the rest for rebuttal.
Yeah, okay. You may proceed.
Thank you. Good afternoon, Sarah Lubin for the people. Defense counsel in the court properly advised defendant that he would not have the opportunity to confront the CI in this case at trial. And the context within which this conversation occurred is important to that analysis, just so that I don't misstate anything. Defense counsel, during a conversation with the court going back and forth about a possible plea, said it is difficult for his client to really accept the proposition that the CI in this case, the CI's statement is not something that the defendant is privy to. The court responded, that is the law, Mr. Hilaire. And defense counsel went on to explain that our hands are tied in reevaluating the credibility of the CI. It's clear in the context of this back and forth that they are discussing the Darden hearing, which did occur in this case. And it seems that defendant, perhaps, I don't want to speculate, but perhaps is interested in knowing what that statement was that the CI made, and perhaps cross-examining the CI on that statement. There's no suggestion here in this back and forth that this has anything to do really with an entrapment defense. And certainly if defense counsel had had conversations with his client about the possibility of an entrapment defense, that perhaps he would have couched his words.
Was it mentioned at all before the trial court?
No, there's never any discussion of an entrapment defense at any point. There's only this discussion of the Darden hearing, which the court does go on to explain.
In leading up to the Darden hearing and in the process of negotiating these cases, was there ever an allegation by the defense that there was a potential entrapment defense on this case?
None that I'm aware of on this record. And certainly it's possible that defendant had conversations with his attorney perhaps outside of court, but that's not something we can possibly know of. That would be something more appropriate.
None of that was communicated to the prosecutors or to the court?
None that I'm aware of.
So it's been a while now, but does the defense not have to put forth defenses such an entrapment as an entrapment defense to the court and to the people prior to the commencement of hearings and trial?
So I don't believe it's a defense such as like a psych defense, that there is a certain notice period that's required by the CPL. However, it is a defense that a defendant would have to make a motion where a court would have to consider and weigh the safety.
Right, so it would have to be a written motion and therefore notice to the court and to the people that they're contemplating an entrapment defense.
Certainly, the people would need to be prepared to produce the CI at trial, make appropriate safety, an appropriate safety plan for the CI. It's really not something that you can show up for trial the morning of and all of a sudden spring on the people.
Is there an issue as to preservation or the lack thereof as well?
Yes, this claim is unpreserved under these circumstances. There's no reason to believe that defendant got bad advice similar to the advice in Piquet, which is the case that defense counsel relies on, that would make it impossible for defendant to have made some sort of motion prior to sentencing.
There was a delay between the taking of the plea and the sentence, correct?
That's correct, actually.
And there was no motion submitted by either the defendant pro se or his counsel to withdraw or vacate this plea.
That's correct. There was a 7-week delay, and actually defendant was at liberty during that time. That was part of the discussions with the judge when he decided to plead guilty, that he would be allowed to remain at liberty during that time. I will just also point out that a defendant does take on a substantial burden in putting on an entrapment defense. This is a defense that a defendant would need to be able to prove by a preponderance of the evidence, and that a bare allegation that someone might want to put one on or that one might exist without anything to support that is not enough to compel the court to disclose the identity of a CI and disclose the identity of a CI under circumstances like that. And there's certainly clear public policy reasons for that. If there's no further questions, I will rely on our brief. Thank you.
I'm going to give you her extra 36 seconds.
Thank you.
Counsel, just to be clear about the facts, you indicated earlier in your arguments that the firearm was found in a bag in a car and not that it was observed from the defendant's lap when the police approached the vehicle?
Correct. And below in the prosecution's response to the defense omnibus, the prosecution had a search incident to arrest theory. At no point below did the prosecution actually present an argument of a plain view. And the fact that there was no probable cause without the CI and no probable cause for a search for an arrest is borne out by the fact that a Darden hearing was ordered and that the prosecution themselves conceded that and asked for the Darden hearing on the basis that the CI was the reason for the approach and not plain view.
This claim. How did you preserve this claim about?
So preservation, again, is not required here, Your Honor, because there was no reasonable or practical ability for Mr. Hilaire to object. There was no way for him to know that this information was incorrect when it was coming from two sources of authority.
Why wasn't there a motion to vacate the plea?
He could not have known, Your Honor. It was coming. He could not have known that the information that he received from the court and from defense counsel was incorrect. Regardless of the amount of time that elapsed, he was entitled to rely on the court's information.
I'm sorry, the information that he could not have known was what? That putting forth an entrapment defense would require the CI to testify, may require the CI to testify at trial?
That he had the right to put on a defense that included calling a particular witness that he was interested in, and that an entrapment defense would have allowed him to do. And Mr. Hilaire did not need to raise at this juncture.
That knowing that he had a right to put on a defense?
That's the crux of this entire issue.
And what is that based on? Because there wasn't a 440. So what is your argument now based on that he was not informed by counsel that he had various defenses and that entrapment was a viable defense?
So that's the affirmative record here. Mr. Hilaire did not need to raise a specific defense to be accurately advised of his right, and the court's statement here that the CI is not of any relevance told Mr. Hilaire there was no way.
My question is, where is it in the record, or is there any indication that counsel failed in advising the defendant of his possible defenses? And again, there's no 440, so how do we know that counsel didn't tell him about this entrapment defense or did tell him about this an entrapment defense?
I believe the affirmative record on pages 2, 3, and 4 of the plea indicate that, because what happened was that he was told by all parties that he could not bring the CI into the courtroom. The entrapment defense would have allowed him to do that, and
assuming that the entrapment defense was viable. And I mean, we're talking as though it is, like it's a fait accompli, and there's nothing in the record to support that.
The entrapment defense did not have to be viable in order for Mr. Hilaire to move to call the CI
Fine,
as a
but
witness.
again, there's nothing in the record wherein it shows that his counsel did not tell him about viable defenses.
And I would submit that the court's broad statement, regardless of what defense counsel may or may not have told him outside of the record.
The broad statement that the CI's testimony or the CI is not relevant as to trial, that in your mind, your argument is that means that the defendant was not informed of the entrapment defense.
It foreclosed the possibility entirely, which meant that he did not knowingly give up his right to present a defense.
Counsel, the court asked the defendant specifically, have you discussed possible defenses with your attorney? And he says yes.
Yes, and again, this goes back to the affirmative record on pages 3 and 4. This is not just an omission or an ambiguity that is curable by other record
But discussing possible defenses based upon your argument that entrapment would be a viable defense, means that that was discussed with the defense attorney.
And regardless if it was, the statement that the CI is not of any relevance would be nowhere near the trial from the judge. That came from the highest authority in the courtroom, the court itself, and Mr. Hilaire was entitled to rely on that. And that is the type of affirmative misstatement under Tyrell that both does not require preservation and that cannot be cured by other record evidence.
Thank you. Johnson versus Montefiore Medical.
May it please the court, my name is Laura Gentile. It's my honor to represent Alma Johnson in this matter. I'd like to start by reading to the court some testimony, one sentence, from defendant Dr. Kuo, page A639 of the appendix, which was not highlighted or discussed in any of the briefs. This is Dr. Kuo, the surgeon. A laceration that was not noticed, it would be a deviation. That's very rare, and it's almost impossible to not notice that you did something to a ureter, that you actually cut, or whatever you did to the ureter. You should have noticed that. And this is a concession of the deviation from
Yeah, but this is an injury which didn't become apparent until 10 days later. So what is the evidence that this is a result of a laceration?
Very good. Even the motion court acknowledged that the signs, which are objective, were apparent immediately after the surgery.
Which signs were those? Because many of the numbers were good.
The creatinine was 50% higher than.
But it lowered over time.
It went down to 1.23 because they were flooding her with fluids, which dilutes the percentage of the creatinine. The motion court found that increased creatinine was sustained the malpractice for the failure to recognize those signs immediately after.
Is the theory of from the experts, is the theory of the case that it was a nick or a cut, or is it that it was devasculation?
It could.
Which one's being asserted?
Theory is that it was an improper clamping. It could have been devascularization. It could have been a heat thing where the tissue would turn white.
But in terms of the expert's testimony, and that being the defendant's expert testimony, not testimony, but affidavit is that this was caused by devasculation, which could only occur, which the signs of it you could only see over a period of time. It wouldn't be necessarily apparent by looking at the.
The motion court rejected that theory when they said that the signs were immediately after. The defendant's theory, which is directly challenged by plaintiff's expert, is that it was an immediate injury, immediate consequences, and you see that the urine output was significantly low because only one.
Is that what the defendant's expert affidavit says in terms of the theory of what happened here?
Defendant's expert theory is that it was some kind of devascularization or possible a thermal injury that didn't manifest for an entire week.
And how did your expert rebut that theory?
He rebuts it with creatinine, and the motion court agrees, creatinine, distension, pain that was unremitting, even with narcotic treatment.
Did your expert specifically speak to this issue of devasculation?
He doesn't address the specific, because that's not his explanation for what happened. We think it was
right, but even if it's not his explanation, he has to rebut what the defendant's expert has said was the cause of the injury.
The rebuttal is that the injury was manifest and could be discerned based on the medical data, the objective evidence immediately after, which the motion court agreed was sufficient to sustain that claim. I can read the court's.
A couple of things. You
Really an
mentioned
injury which doesn't manifest itself until 10
exactly.
days later.
So it was consistent. That's the whole point. It was consistent with the devascularization, right?
No.
According to the experts, it was that it would occur over a period of time, and that's what occurred in this situation.
Even if that were the case, which we don't concede, it would have been revealed by a cystoscopy, which reveals these small injuries. And defendants repeatedly say this was incredibly difficult.
That wouldn't show devascularization.
Right.
Yes, that's cutting.
A cystoscopy would show devascularization?
I beg your pardon?
A cystoscopy performed at the time would show devascularization, which takes time to manifest itself?
There's no validity to the theory that it manifests itself a week later.
So what in the record establishes that? And just point out.
Acute until a week.
I'm sorry.
She does not. Her symptoms do not become acute for a week.
They sent her home.
No, they sent her home
without a problem.
And she said she was fine. She didn't say she was 100%, but she said the pain was less than what it had been before.
She was on narcotic pain medication, which at that point she should not have been. Our expert raises question of fact over question of fact.
Where does it say she should not have been? Where does it say that she should not have been on pain medication when she's sent home?
We're not saying she shouldn't have been. We're saying that that has to be taken into account.
Where does it say in the record that the fact that she was on the pain meds in any way masked or would mask the symptoms?
It's in our expert affirmation. I'll pull it out if you want.
Because I did not see that.
Also, counsel, where in the record does it say that this injury was immediately apparent? Like, what information do we have to support that?
The motion court.
Not the motion court, in terms of the expert affidavit.
50% increase in creatinine. It should not have occurred. It never.
Does an expert say that in the affidavit?
Absolutely.
Okay.
The decreased urinary output was significantly reduced. It should not have been. These are abnormal signs and symptoms.
But during the time that she was in the hospital, my understanding from the surgical records is that she had relatively normal urine output.
No, that's not correct.
That's
and
not
our
correct.
expert goes through day by day and urine
That's what
output by
that's
urine
what
output.
the post-op says, that it was normal, that the urine output was normal, and that was one of the reasons why she was released.
No, her urine output was not normal, and if you look at the actual numbers and what our expert explains, our expert goes through and shows what the urine should be based on a normal urine output, and that hers was significantly reduced. I'll pull out, when I sit down, I will pull out and refer to the citations in the record.
All right, why don't you do that, and we'll hear from the other side.
May it please the court, Susan Etra from the law firm of Yoeli Gottlieb and Etra on behalf of the respondents, Montefiore Medical Center, Dr. Dennis Quo, and Dr. Miller.
So one of the problems is Dr. Quo was a little tentative in terms of exactly what he did, what he didn't do. Some of his testimony relied on what he normally would do.
Well, all right, before
That's sufficient?
you want me to address the habit evidence, I'll be happy to do that first.
Yes, please.
This is the first time in the history of this case the plaintiff has raised this.
That wasn't raised below.
It was not raised below. The new claim, which is the number one point in the appellant's brief, is that because all of Dr. Quo's testimony with respect to what he did during this procedure is based on habit evidence, it should not have been considered by the lower court and could not raise a question of fact, and that summary judgment should not be given. That was not an issue raised in the lower court. Not one case that has now been cited in these papers was raised before the lower court. That argument should not even be considered based on prior case law. But if you were...
If the court's review of the record shows that your client's affidavit and the medical records from the operation are not in sync, why couldn't we look at that?
Okay, there is no claim, by the way, that the medical...
I'm looking at the records, I'm looking at what he said. If I don't think they match, why isn't that enough?
Okay, the issue with respect to habitual evidence is really a smokescreen here because Dr. Quote
Where in the operative report does he say, we actually did this? We actually carved a tunnel. We actually dissected the urethra from the wall in a safe way without incident. Where in the report does it actually say that?
The operative report states at 204, bilateral ureters were identified crossing the medial aspect of the retroperitoneum. The ureters were identified and moved away from the infundibulopelvic ligament. The right ureter, which is the one that was subsequently discovered as having been injured, was identified and moved away. That's docket 194 at 021411. The surgeons wanted to be meticulous in order to protect the ureters. That's in the operative report. The operative report made it clear there were no complications. In their testimony at A 1983 and 1984, Dr. Quote testified, not based on habit, in this surgery, he protected the ureters with tunneling. In this quote, in this particular case, we turned the ureter by opening the space that is above the right ureter, allowing us to dissect the ureter laterally and posteriorly away from the uterine and cervical mass.
Counsel, what about the issue with regard to him looking at the ureter before he closed up the patient to see whether there was any damage and inspecting that? He said what he usually does, and then the records are silent on whether that in fact happens.
But Dr. Quotes testified and Dr. Miller testified, both of who were the surgeons at the procedure. This is an open procedure. They saw the ureters throughout the entire procedure.
Right, but the question is not whether they saw it during the entire procedure, because apparently something happened to it alleged during the procedure. But the question is, before they closed up the patient, did they examine it to make sure that it wasn't this pink color that could suggest that there was an issue with it?
The doctor testified that he always examined the ureters.
That he always, that's habit, right?
If I may, respectfully, he's testified that he always examines the ureters as well as everything else that's in the operative field before closure. His custom and practice testimony on this is solely with respect to documentation. He testified that the operative report says there were no complications. He testified the standard of care when he dictates operative reports, if he looks in the operative field and everything's normal, he does not dictate in an operative report, the pancreas looks normal,
Right,
ureters
but
look, if there's a problem, he would document it, and if there's no problem, then the operative report says no
what do we do about the issue that plaintiff's expert says that it would have been, that if he had looked, he would have noticed or seen that there was an issue?
The plaintiff's attorney did not give expert testimony along those lines. What the plaintiff's attorney's expert testified to on this point. There are only, I just want to simplify for the court to answer your question. There are three issues on liability with respect to the surgeons. One is whether they properly protected the ureters, and the second one is whether they should have done a cystoscopy at the end of the procedure. The evidence, the testimony in the operative report showed, pursuant to the plaintiff's expert's own standard of care, that preoperatively, he said you have one or two things you have to do. You either call in a urology consult and have them insert catheters to protect the ureters, to protect them, or if you don't do that, then at the time of surgery, you have to dissect the ureters and perform tunneling to keep them protected. All the testimony and the records show that.
Dr. Brewer directly addresses the cystoscopy, page 834. Since the ureters could be visualized and were intact, there was no need for any tests like a cystoscopy to check the ureter
Sorry, I didn't hear the
functioning.
first part of what you said.
I said Dr. Brewer directly addresses the cystoscopy issue on page 834. Since the ureters could be visualized and were intact, there was no need for any tests like a cystoscopy to check the ureter functioning.
Exactly, and the reason she said that is getting to the second issue. Plaintiff's expert testified, and I will quote him what he said. He said, when the surgeon is faced with difficulty visualizing the ureters, it's even more important, and the standard of care requires post-operative cystoscopy. In this case, he had no... I'm sorry.
Please.
I'm sorry.
doesn't the Dr. Quo say repeatedly that he was having difficulty visualizing because she was so obese?
Respectfully, he never said that anywhere in his testimony. What he did say, and this
Nowhere. So if I look at this record, none of the doctors in that operating room said that they were having difficulty visualizing. I made that up.
no, the plaintiff's
Counsel, I'm looking at
counsel
the
and their
operative,
expert made it up.
counsel, if I may, the operative report at page A16, I have the higher numbers, A1632, given the patient's morbid obesity, this portion of the procedure was very difficult, and going forward visualization was challenging given her morbid obesity.
That is correct. What they are distorting.
So I didn't misstate it.
No, you're correct. You're correct that the word difficulty was used, Your Honor. But what the testimony is by Dr. Quo, he is a GYN oncological surgeon. He does very difficult cases, and his testimony, and you can read it. He said there was difficulty visualizing.
Difficulty doesn't mean that you can't see.
Difficulty performing a procedure does not equate to difficulty visualizing the ureters. Difficulty performing the procedure means it was a harder procedure than others. That doesn't mean it can't be correctly performed and expertly performed. Dr. Quo is a GYN oncology surgeon who does very, very difficult operations all the time. And what they are distorting here, excuse me for raising my voice, what they're distorting here is the notion that because it was a difficult surgery, he had difficulty visualizing the ureters. Based on their own experts' testimony as what the standard of care required him to do during this surgery, he absolutely did them, and there's nothing to refute that.
Thank you.
As far, if I could just add, as far as what counsel is misleading the court on, is there's no rule of this case that there was evidence of a injury to the ureter postoperatively. The whole postoperative care in this case is still left for trial.
At some point, right?
It is
obviously she had an injury.
She
right?
Clearly had an injury, and it is clearly a known and recognized complication of this surgery as per their expert and ours.
Thank you.
Questions of fact for the jury to resolve are rife throughout here. The operative report, visualization was challenging. Quo.
Visualization of what?
Visualization of her anatomy, her entire anatomy. They said that she was obese and the tumor was so big that the visual, I mean, I'll give you
the tumor was very big. The tumor was very big. That's an absolute fact.
It was almost.
I'm not yes, which is why we needed the cystoscopy, because there were all these difficulties. And do you want the citation?
Why did your expert say about what Dr. Brewer says, since the ureters could be visualized and were intact, there was no need for any tests like a cystoscopy to check the ureter functioning. Although some physicians think that a cystoscopy will help see a renal injury, it will not. It will only visualize a bladder injury.
I couldn't hear the last part, but
the last part was about the fact that a cystoscopy can only really see a bladder injury and not a ureter injury.
Our expert directly contradicts that and said, and which makes it a question of fact for a jury to decide. Our expert is very clear. You put the fluid and the dye in the ureters, and if there is an injury, the leak comes out. It even can come out in the urine bag to show the injury. And defendants are trying to have it both ways. They're trying to say this was an incredibly difficult surgery, but we didn't have to take this specific precaution of the cystoscopy.
There was something in the record in one of the doctor's affidavit that said because it was an open surgery and not an open surgery, that's the reason why you don't need to do a cystoscopy, because you're able to openly see the organs. How did your expert rebut that?
Well, and yet there was an injury, which I think belies the accuracy of that statement. If open procedures resulted in no injuries, our client would not be in
But
cover.
your expert also said that this type of injury happens in about 1%, and it's a and one of the things there's a potential problem with this type of surgery.
He also was very clear that it does not occur in the absence of negligence. Sometimes people die in surgery. That's a known risk. That doesn't mean it's an accepted risk or that death did not occur.
Your expert says during the hysterectomy, Dr. Cohn, Dr. Miller clamped the right ureter improperly. The urine leaked into Ms. Johnson's abdomen when her right ureter ruptured due to the pressure of the urine backing up in the ureter and kidney. Doesn't that directly contradict the surgical report?
No, there was the clamping. It was the clamping.
There's nothing in the surgical report to establish that urine immediately started to back up in the ureter.
And it wouldn't have taken 10 days for the injury to manifest itself if the urine was immediately backing up.
That's right, and it didn't take 10 days. It was the very day of the surgery. Her creatinine spiked at 50% higher than normal.
If this is accurate, what your expert says, she's not going home right after the surgery as she was sent home.
That's
So this
right,
is just,
and she
this is just completely contradicted to what the facts are and to what the surgical report says.
She stayed 4 days. If everything was fine, they kept her because of the pain, because of the creatinine, because of her abnormal signs. That's why she.
But there's nothing in the record that says that those were abnormal signs. In fact, they were saying that they were leveling out to normal, which is why they released her. You're shaking your head? No, but that's what the record says. Okay.
All right, thank you so much.
Did you want my
No,
citations?
thank you so much. We have the record and the briefs. Have a good day.
Thank you for your time,
You are welcome.
and happy holidays.
Same to you. People versus Akeem Massey. No, not Massey. People versus George Lazaro.
Huh?
Gentlemen, you're at the end of the calendar, I'm afraid. You may proceed.
The question is whether the court's misstatement of law that Mr. Lazaro was not entitled to additional discovery pursuant to CPS.
How is that a misstatement of law? Well, and how is it a misstatement of law? The issue was whether, under the statute 245-25, it states that the prosecution must turn over the discovery prior to the defendant making a determination of a plea, where the plea is being offered by the prosecution. Here, the plea was being offered by the court.
So, Your Honor, there's two. Yes, Your Honor, that was argued below as well. So, one, I'm going to address both of the arguments the court made. First, the court argues about the critical date. What is the relevant date? And the court says the relevant date is when the plea was entered. At the plea hearing, we're arguing back and forth that the plea had not yet been entered. The court says, well, the law that was governed at the time of the plea agreement was prior to February 11th, 2020. We do not enter the plea into February 11th, 2020. So the court arguing that the law at the time, which is 2019, is not relevant because this court has agreed that CPL 245 is not retroactive and that it applies when.
So when was this whole package put together wherein it was understood that the defendant was going to ultimately take this plea? He was going to step in for 4 months, I think, and then after the 4 months, he was going to take the plea. When did that occur?
That happened in, I believe, October 2019.
October 2019. And when did this law go into effect?
January 2020.
Okay, so at the time that the plea was negotiated, it was understood this law had not gone into effect as of yet.
That is correct. And then there's been a lot of law. When does 245 come into play? And this court has stated it has no retroactive. It is still applicable prior to trial. So obviously this is not a case that went to trial. So it is still relevant because we did not yet plea.
Okay.
So I agree with you, Your Honor, that the agreement was designed prior to 2020, but we had not yet pled. And so on January 2020, we asked for the additional discovery.
Okay, and so this goes back to my point that 245-25 is not applicable to an offer made by the court. It is only applicable to an offer made by the prosecution.
Your Honor, their explicit language talks about prosecution offers. I also want to be clear, respondents' papers in page 6, when they state the facts, they state that this was also a prosecution offer, that the people offered.
Prosecution went along with it. I don't believe it was their offer. I thought they went along with it.
So, Your Honor, the statute does say prosecution.
I appreciate your work. I used to do your work, okay? But the plea that was worked out here was a gift for this defendant. This was the best possible outcome for him under the circumstances. Am I right? It was negotiated over a very long period of time. The court put itself out there in these very unique circumstances, someone with limited capacity, right? And so what are we talking about here?
So, Your Honor, the legislative intent is that for people to have discovery prior to taking the plea. That was the goal of CPL.
Counsel, you're not answering the question. This was a very, very unusual plea offer.
Yes, Your Honor, it was the best plea offer that was able in 2019. We do not deny.
And then when there was a return date, the tenor of the conversation or the tenor of the discussion before the court or with the court changed entirely, which was, we want discovery now. So the court said, well, if you want discovery, then we start fresh. The offer is off the table.
Your Honor,
What's wrong with that?
Your Honor.
Since it was the court's offer, and the court had already expended a tremendous amount of time, judicial resources, trying to get the two of you together to reach a result that would be beneficial to this very,
yes, Your Honor,
delicate client, right? And so what are we doing?
Your Honor, we complied with all the requests of the court.
Right.
You
And
have
so-
to
but
earn
what
a good
is
offer.
the goal here, right? So if we were to grant this, right, then what happens? We let your client take his plea back and start over?
Your Honor, but it is
because you can't seriously think that we would dismiss the case.
No.
And so what are we doing?
Well, Your Honor, there is a question of law on whether 245 applies to judge offers.
It
There's
doesn't.
also-
It specifically says where the prosecution has made a guilty plea offer requiring a plea to a crime, the prosecutor must disclose to the defense all items and information that would be discoverable prior to trial. Now, I understand you started to talk about legislative intent, and perhaps the overall intent was that defendants should be given all discovery prior to their making a determination as to whether they're going to accept a plea or not, and I may agree with that, but the statute is clear. It talks only about where the prosecution has made a guilty plea offer.
And so earlier,
Because it could have just said where there's a plea. It didn't have to put
Exactly.
in the word prosecutor.
so that means, Your Honor, if the prosecution also agrees to the court offer, then that means defendants are exempt from getting the privilege of having all the discovery prior to taking the offer. It is not saying
Under that provision.
Right, and all that says is that as a defense counsel, you don't go to the court for an offer until you have all of the discovery, right? If you walk out the application of this legal principle, if we're gonna put this in place as precedent, defense counsels are on notice. You don't go to the court, have the court convene all of its resources and extend an offer to you before you have the discovery, because the court has no obligation to give you discovery because the court doesn't have discovery, right?
Your Honor, I just want to say that this all started prior to 2020. And so I hear that from going forward, now we will not take judges' offers because the judge is exempt from CPL 245.
We're not saying not to take judges' offers. What we're saying is when a defense attorney elects to take a judge's offer, then
CP
245
does not apply.
in that
Yes.
way. That's all.
And it's also not just elect, right? Because the judge is not just sitting there saying, oh, I want to make offers, right? We all know that in practice. Defense counsel is saying, Judge, what offer would you make my client, right?
So yes, Your Honor.
Okay.
I just want to end by saying that there's also the fact that the judge not only withdraw its offer, it then talks about the contemplation of bail. The court could have withdrew its offer, and because there has been 3.5 years of this client being in the community with no risk, no rearrest.
No risk. He was at risk of being deported if he took a guilty plea. And here, counsel,
Risk of
reoffense,
flight risk, like the factors under bail. He was not a flight risk or risk of not coming back to
But again, he was going to be reinstated to the original bail status, but that would not preclude you from making a bail application.
And the court didn't use bail as some sort of threat. That was just the next natural posture of the case had the client said that they didn't want the offer,
Right, and I
which is
think
what they said.
I think the question, I don't remember who asked, whether it was the prosecution or the defense who asked what was the original bail. And the prosecution asked, and then the court just stated it was, I think, 30,000, over 30,000, something
be
of
clear,
this
Your
nature.
Honor, the judge,
The defendant made.
well,
Right.
Your Honor, the judge asked the prosecution, what is your position on bail? We had already said that supervised release had already, would accept our client, and that he
And
had,
the supervised release is a sentence, right?
no,
That's
Yeah,
a
it's
supervised
a
release.
bail condition.
A
It's,
bail
it was a new bail condition.
It's a
of the
bail
new-
condition. But
I
again,
didn't have those when
yeah,
I
I know
was in the-
2020 is like you, it's like 2020 is like.
it was only
It's a third form.
Yeah, it was only remand for me. But anyhow, again, he just is going to be placed back on the original bail status, which was the 30,000, over 30,000, which he apparently made. It was not that the remand status is going to remain or anything of that nature.
And a question is not a threat, right? It was a question. It
Exactly.
wasn't a statement, oh, now I'm imposing bail. It was, what's your position on bail? That equates to a
Give you
threat?
time on the other side, okay?
Sorry.
That's okay.
Good afternoon.
Go ahead.
May it please the court, Margaret Crookston for the people. Your Honors, as you noted, this was a very favorable deal that had been in the
It was
months.
10 years probation.
Yes, so the effective, it was, to clarify, it was the people's recommendation was a 6-month split.
Right, that's
The
what I
judge noted he was willing to go with this, as you noted, very unique procedural procedure here because it was the functional equivalent of the people's recommendation of a 6-month split.
So are you conceding that it was the people's offer then?
No, the people were recommending this, and in terms of the negotiations with the court said he was willing to do let him serve the time because the court noted, I'm doing this because it is the functional equivalent, and I.
Right, so if it's the functional equivalent, then it's the people's offer. Then the court is going along with the people's offer. It's still the people's offer. So why would 245.25 apply under those circumstances?
So I think the people were agreeing. As I said, this was a long negotiation here, but the people were asking for the regular 6-month split, and then the court was working with.
A 6-month split turns out to 4 months incarceration, does it not?
Yes, Your Honor.
Okay, so, and the defendant did 4 months incarceration, did he not?
He did, yes, Your Honor.
So it's the same thing.
Yes.
So it's the people's offer.
The people specifically said this is not their offer. The court specifically said this is my offer.
Going around in circles.
Yes, Your Honor.
The people did not say, okay, 4 months, he has to step in now, and then in 4 months, he can take the plea, and then it'll be 10 years probation. People didn't say that. The people said, we want 6 months and probation, knowing that 6 months equals 4 months incarceration with the 10 years
Doing
probation.
it this way was very advantageous to the defendant. Now, the people didn't jump up and down in opposition to this, but it wasn't their offer.
That is correct, Your Honor. And
The people just wanted a traditional, you plead guilty, you're supposed to serve 4 months, and then you go on to probation.
Yes, Your Honor, and I think.
But you can see how this could be viewed as a way to circumvent 245.25, which we all know, and I think it's even mentioned in the papers, that it has been allegedly onerous to the prosecutors in order to have to compile all the discovery. So again, it could be seen, it could be argued that it's a way to circumvent the statute.
And I recognize that.
I would never argue such a thing, but,
Well, defense counsel doesn't have to play along with that. He can say, I'm not taking the judge's offer, give me my discovery, and then we'll talk.
Exactly.
And then the offer's off the table?
And I think what's really relevant here, Your Honors, is how much of these negotiations and how much was done off the record. And we see that at the October 15th hearing where the defense counsel specifically says, we've talked about this a lot. I know in chambers so how much of this was fashioned outside and agreed to isn't explicitly clear on the record. And here we have the court saying, this is my offer, this is not the people's offer, this is the people saying this is not my offer. And even if moving away from that, we say somehow this does apply, the statute specifically directs that any discovery violations need to be considered and whether they affected the defendant's decision to plead guilty. And here we know there was no effect because defense counsel said at least half a dozen times that they did not want to go to trial. They did not want to confront this evidence. This evidence was going to have no impact on the defendant's decision to plead guilty. He was going to plead guilty regardless of it. And I think that was the posture before the court, and I think that explains why the court may have been a bit inarticulate in when the plea date was affected, because there was an understanding in place, there was an agreement, and I think all the parties were aware of what had been turned over, whether it was going to have an impact. And just to be very clear, there was no threat of remand. There was no indication before the court at all that anyone on the record believed that remand was at issue in that moment. So if there are no further questions, I ask that you affirm.
Thank you so much.
Your Honors, I do want to start off by when Mr. Lazaro is allocuted to the plea, the court says, Mr. Lazaro, you are entitled to pretrial discovery in this case as a result of the guilty plea. The pretrial discovery process will stop. However, the guilty plea is not conditioned on the waiver of further discovery. I want to highlight that, Your Honors, because it seems very inconsistent to say you are not entitled to pretrial discovery under 240 CPL 245 because it is a judge offer, but then in allocution, you make that notation. Also, Your Honor, below respondents, they do not argue that they were not entitled to give discovery because it is a judge offer. They state that they were overburdened and they thought the plea would go forward regardless. And then when defense counsel says the people are not relieved of their obligation to provide us with discovery, even though they felt that this disposition was in place, prosecution does not object to that at all either. I also want to note it is a covering ADA that was at the appearance, but these are the statements that were made that create some contradiction that additional discovery is given to defendant under CPL 245 if the prosecution also agrees with the judge's offer or things of that nature. And I do think if this court thinks the law is clear, I do think it is a question of first impression.
All right, last but not least, gentlemen, Ellison versus Schulte.
Thank you. Good afternoon. May it please the court, Ira Glauber from Dilworth Paxson, counsel for appellant Sandra Schulte. This appeal relates to the lower court's erroneous decision to apply the doctrine of res judicata where it clearly does not apply. We all know that res judicata applies only if the two actions involve the same parties and the same claims. Here, there were different parties. The prior proceeding
Isn't the issue about actual possession of the apartment is off the table? I mean, she's out. So the question is, what, if any, of your counterclaims can be restored?
All three of them. The first one, the most important one, is for a replacement apartment. That is based on the prenuptial agreement that was signed in 2004.
What about the one which seeks return of maintenance? What basis is there for return of
Your Honor, the return of maintenance, that one falls by the way.
So it's not all of them.
That's not. There are three counterclaims that are issued here. One, the claim for a replacement apartment, which is based on the prenuptial agreement. Two, a claim for the alternative claim for a 1/3 elective share that she gave up in reliance on the prenuptial agreement. And the third counterclaim is for a reformation or equitable deviation from the terms of the will.
What's the third counterclaim for?
It's equitable deviation from the terms of the will. We all know she cannot be put back in that apartment. We realize.
Isn't that the fifth counterclaim?
I believe that is the fifth one.
So you're not seeking the third one either. You're seeking the first, the second, and the fifth?
We're seeking the first, the second, and the fifth. That is absolutely correct. Let's talk about the prenuptial agreement. What did Mrs. Schulte give up, And what did she get under it? She gave up millions of dollars of her inheritance by giving up her 1/3 elective share. She also was the beneficiary under the father's trust, believe it or not, that goes back to the 30s. She gave that up as well. She gave up millions of dollars. What was she promised in return by the decedent? A life estate in the apartment. She is very much alive today. She's been deprived of her life estate, and so these counterclaims are to compensate her for what she lost. Now, the first case that's what the fundamental mistake of the lower court. The first case was against the co-op. It wasn't against the estate. The estate and Mrs. Schulte were united in interest. The surrogates saw
Your
that.
point is that she couldn't be seeking the relief she now seeks until she lost the apartment.
Absolutely.
So it couldn't be res judicata.
Absolutely. None of that. The
Claim doesn't arise until she's out of the apartment.
Of course, but on top of that, the claim didn't even arise yet. The claim for a replacement apartment is based on breach of contract. The contract said that she can elect at any time a replacement apartment. She didn't want a replacement apartment. The husband didn't want her to have a replacement apartment. She elected the replacement apartment when she asserted the counterclaims in 2024, and the estate ignored it. That was the breach. That's why the cause of action did not accrue. She could not sue the estate before for breach of contract for a replacement apartment, even if she elected it. But she didn't because the claim had not yet accrued. The decision below is a huge windfall for the estate, which ain't fair. The estate, there was an apartment worth $8 million in which unquestionably she had a life estate in it because she gave up so much for that life estate. As a result of the lower court's decision, that estate is now able to sell that apartment for $8 million while Mrs. Schulte is still alive. Not fair. She has to be compensated in some way. There was a failure of consideration here. She gave valuable consideration for that prenuptial agreement, and she didn't get full consideration for it.
Thank you, and you'll have
Thank you.
time on rebuttal.
If it pleases the court, Bradley Silverbush from Rosenberg and Estes for the respondent. I want to correct a misstatement or misconception. This claim of equitable deviation accrued either when the decedent died in 2005 or when the co-op denied her request to transfer the apartment in 2010. Ms. Schulte received permission of surrogates court to substitute it as an
So long as
executor.
she's living in the apartment, is she really aggrieved enough that she's got to do anything?
Well, what happened is the co-op served a notice of termination after they declined the,
When she's out of the apartment, that's when she needs someplace else to live. And
She's living in her own co-op. She's a wealthy woman. This is not.
That's irrelevant.
Yeah, I agree. It's completely irrelevant. She has her own co-op where she's living. She voluntarily moved out of the apartment. We have possession's
The
not.
initial petition in the surrogates court was filed in her capacity as co-trustee of the marital trust, correct?
Yes, Your Honor.
And she couldn't file her suit then.
Yeah, in fact, when she
No.
was.
As a trustee of the marital trust, she could not assert individual claims against the estate in that context.
Well, she was granted permission to amend the complaint, and she did nothing with that.
Permission does not mean as of right, correct?
I'm sorry, Your Honor?
If she has to seek permission to do something, she cannot do that as of right. So it is incorrect that as a co-trustee of the marital trust, she could have asserted her individual claims against the estate in that context.
Well, that's really
So
my.
how about in her limited role as the administrator?
Your Honor, that presupposes that she made such a request. The record is devoid of any indication she ever made a request to do so. Once the request to transfer was declined, she could have made a request. She had a right under the prenuptial to direct the trustees of the marital trust to sell the
But
penthouse.
she could not serve an individual claim in that capacity.
She could have because she never made
She could not.
I agree, because she never made the request that is a precondition to doing so. She had to have made a request to have the trust sell the penthouse and use the proceeds. The record is devoid of any indication she ever made that request until, as counsel just said, until she filed the 2024 counterclaim. That's the first time she made the request. And the court below never addressed the issue of the statute of limitations. What has she been doing for the last, almost 2 decades? She could have asserted these claims.
Decades.
I'm sorry, Your Honor?
How long were these people married?
About a year.
So what, 2 decades? What are you
Oh,
talking
no,
about?
I'm talking about since he died. He died in 2005,
Okay.
right? And the equitable deviation claim could have been asserted any time after 2005.
How, if the prenup, she gave up those rights in the prenup?
Your Honor, the same arguments he's advancing now could have been made in 2006 or 2011. That's all I'm saying. It's almost, and it overlooks the privity between Sandra Schulte as executor and as a beneficiary. I mean, it's the same person. It's not like you had 2 different people deciding or pulling the strings on the course of action the case was going to take. I mean, this case has been in this court, I believe, 3 times already. And Your Honor, I think, was even on the panel that affirmed surrogate's court, and they talked about the fact that she was sitting on her rights for many years and didn't pursue them. And when she finally sought to amend, this court affirmed the holding that the claims were fairly, you didn't use the word ridiculous, but fairly unsupportable or something to that effect.
I have a question about the second counterclaim here, which alleges that the defendant was entitled to an order declaring that plaintiff was obliged to find her a replacement property, right? Did the plaintiff assist the defendant in any way in her quest to remain in the apartment? Or was she hands-off during the whole battle with the co-op?
My client? No, as counsel characterized it correctly. We were unified in interest. We worked together to try to get the co-op to
That's what I
approve the
thought.
transfer. Yes. We had no animosity towards her whatsoever, and we joined in the request. And Ms. Schulte was so frustrated with the co-op's actions, not my client's actions, that she then petitioned the court to be able to have limited letters so that she could pursue, and we consented to that request. We never opposed that request. And the only reason we brought this action was because the co-op was threatening to terminate our proprietary lease. They served us with the notice of termination because we had failed to take any action.
What's your response to your colleague's central argument that she had this right to live in this apartment, had a life estate in this apartment, and now she doesn't have that anymore? She deserves to be compensated for that.
Well, she didn't have that as of 2010, Your Honor, when the co-op made its finding that this was not a permissible transfer under the co-op's rules, a holding that
But the
this
idea
court
was
affirmed.
that she was supposed to have this benefit.
Yeah, there's no question that's what the prenuptial provided for. She was supposed to have this tenancy, or alternatively, the proceeds were to be used to.
So how does she get compensated? Are you saying that she's too late in acting, but really she should have had this benefit?
I mean, we can't turn back the clock. I mean,
But how does she get compensated? I mean, she had a life estate. She no longer has a life estate. Perhaps through no fault of your client. But so how is she compensated?
I don't know that she's.
Well, the prenup said that if for whatever reason, she couldn't stay in the apartment, that she should get a replacement apartment. So that's what should happen, right?
No, that's not what's.
Why not?
She had to elect to do that. She never made that election. It's very clear.
And where in the will does the father say that she has a certain time?
Oh, it doesn't say.
Does it limit it in any way?
No, Your Honor, but.
Okay, so the delay was not occasioned by the plaintiff here. And again, it's not your client's fault that the co-op took the position that they took, but they did. And so here we are. So the fact that they throw a roadblock, I fight as long as I can't fight anymore, so now you get nothing?
No, first,
I get to ignore my father's will that says, give her a replacement apartment?
first of all, she's still getting plenty under the estate. We're just
That's
talking.
not the issue. The issue is whether there was a testamentary gift that was intended for this woman and whether that has been fulfilled.
Your Honor, how long is she allowed to wait?
You don't
before
get
she
to ask the
pursues
court
that?
questions. I'm sure that's a rhetorical statement on your part.
I recognize it as such, but I'm just curious, what is the court's view of the statute of limitations? Because the lower court never addressed that issue. You know, if this right arose in 2010, how long should a person reasonably be expected to, you know, raise that argument? 5 years, 10 years? In this
However
case,
long it takes to fight it, I guess.
well,
You said something about the co-op is threatening the plaintiff with terminating the proprietary lease. Did you say that?
yes, that's what precipitated a lot of
Proprietary
this.
lease
The
for
co-op served the
this
termination
apartment?
notice.
Yeah,
For the unit?
yeah.
So the apartment remains in the control of the plaintiff?
Well, what happened is we did a standstill agreement on the
I'm
termination
sorry, you did
notice.
a what?
We did a standstill agreement with the co-op to they agreed not to enforce the termination notice, and we would commence an action to recover possession. And during the
Because the
course,
papers kind of reveal that there's a board member who has their eyes and sights on this apartment.
and that turned out to be completely untrue, as this court found. She did complete discovery on that. In fact, he bought another unit in the building. It had nothing to do with this apartment.
Maybe because this one wasn't available.
You could speculate, but the testimony does not support that conclusion, Your Honor. Thank you.
Counsel?
Very briefly, the statute of limitations, and is the statute of limitations an issue here?
No, because the cause of action did not accrue. It cannot accrue until there's a breach. There was no breach until the estate refused to give her a replacement apartment. That took place in 2024. In answer to your question, the prenuptial agreement says that she may elect a replacement apartment at any time. She was not obligated to elect it back in 2011 or any other time. She litigated for 20 years against the co-op because she genuinely thought that the co-op should not have done what they did. That's not the issue before us today. But why should she be deprived of her life estate in the apartment that her husband granted to her by contract simply because she litigated for those 20 years? It just doesn't make any sense. The equitable deviation argument, you must exhaust all remedies. And so it took until 2024 to exhaust her remedies against the co-op. And only once that decision came down, that's when the cause of action arose or accrued or matured. So there is no statute of limitations issue.
Thank you.
Thank you.
Holidays.
Thank you. Hey, how are you? Good to see you.